Today is August 14th, 2023. This is day 3 of the evidentiary hearing for the general rate case of Confluence Rivers Utility Operating Company. The case citation is WR-2023-0006. We'll go ahead and make quick entries of appearance for the council present. We'll start with Confluence Rivers.
Judge Dean Cooper from the law firm of Bride and Swearingen in England, appearing on behalf of Confluence Rivers today, along with Mr. Mitten and Mr. Woodsmall, who appeared last week in the case.
Thank you, sir. Glad to see that you're feeling better. For staff.
Good morning, Judge. Kevin Thompson and Karen Bretz for the staff of the Missouri Public Service Commission, Post Office Box 360, Jefferson City, Missouri 65101.
Thank you. And the Office of the Public Counsel.
John Kleiser, Your Honor. Thank you.
Thank you. Quick announcement. Last week, seemingly crossing communications, the commission had inquired about the availability of witnesses to discuss options on rate consolidation. In about the same time period, it was reported that there was a pending settlement among the parties. And to summarize from council, that was 2 water, 2 sewer, and divided by cost of technology, for lack of any term of art on this. The commission is no longer interested due to the parties having settled that. So just to let all the witnesses know, I'm sure they're listening. Today's schedule includes, and this is the reason I mentioned the commission's interest, includes issue number 5, rate design and district consolidation. However, the only live issue is the 2 competing estimates of water usage. Staff's recommendation of 5,000 gallons estimated per month versus the company's 2,750 gallons. The next issue for today is acquisition-related costs and then timesheets. Okay, let's go to many.
Your Honor, can I inquire real quick?
Yes, please.
I don't know just to delve a little deeper into the rate design issue, the parties had waived cross of the witnesses, but you indicated last week that the commission may have questions on the water usage issue. Mr. Lyons is available to dial in tomorrow after we finish costs of capital, about 12:30. He's available if that fits the commission's schedule.
Thank you for reminding me. Thank you. I don't believe that the commission has questions. However, I'm going to leave that until tomorrow at 12:30. I want to double check on that.
I'll have him on hot standby.
Thank you, sir. Speaking in the background was David Woodsmall, counsel for Confluence Rivers. How does council want to handle? Let's just move on to issue 6. Acquisition-related costs. Okay, let's start with many opening statements. We'll go with the company first. Mr. Cooper, the floor is yours.
Thank you, Judge. This is the issue that I believe Mr. Woodsmall referred to in his opening statement as preliminary legal and engineering costs. As we've talked about several times in this case already, Confluence Rivers, of course, acquires the assets of small distressed water and sewer utilities. Sometimes Confluence Rivers is acquiring assets from existing water and/or sewer corporations, and many times it is acquiring systems that are either being run by non-regulated entities or entities that have been should have been regulated but have not submitted themselves to such. In acquiring these assets, Confluence Rivers incurs costs both before and immediately subsequent to the acquisition that primarily arise from necessary legal and engineering expenditures directly related to the acquisitions. The engineering expenditures include costs for system maps and surveys that are necessary to ultimately operate the systems. These costs also include expenditures that allow the company to determine the feasibility of capital improvements that will need to be made to the system. The legal expenditures include costs associated with securing clean title to the property, confirming, or in some cases acquiring, proper easement access to the system components, and the cost to appropriately file required acquisition cases with the Commission. Consistent with the uniform system of accounts, Confluence Rivers books such legal and preliminary engineering costs to account 183, preliminary survey and investigation charges. The staff, and the reason we're here today, of course, is that staff seeks to disallow these costs. Well, let me back up. First off, I think I want to make clear that the costs in account 183 ultimately are capitalized and included in rate base. So when we talk about the amount of costs that have been disallowed, slightly more than $1.2 million in costs, that is a rate base number, not a revenue requirement number. Now, this approach represents a drastic shift in course for staff. Specifically, these costs have been allowed in the previous rate cases related to Confluence Rivers and its predecessors. On Friday, associated with a similar sort of issue, I think we ended up with some conversation about staff-assisted rate cases versus a general rate case such as this one. And I do want to point out that Confluence Rivers still qualifies to use the staff-assisted rate case procedure. This is not a situation where it's outgrown that procedure. The company filed this case as a general rate case because of an agreement with staff in a prior acquisition case. So just a point of clarification as we think about those issues. Having said that, I don't believe there's any reason that an answer to a question like this in a staff-assisted rate case would be any different than an answer in a general rate case. Now, staff's reliance in this case on past commission cases concerning transaction costs related to mergers of regulated, well-established electric corporations is misplaced. Those cases bear no resemblance to the types of small, distressed water and sewer systems being acquired by Confluence Rivers, nor do they reflect consideration of the improvements to systems that can be delivered as a result of Confluence Rivers acquisitions. Given that Confluence Rivers costs at issue are recorded and capitalized consistent with the USOA, and the resulting improvements to the systems cannot occur without such costs, the Commission should reject staff's disallowance. That's all I have.
Thank you, Mr. Cooper. Any questions from the commissioners for Mr. Cooper? Go ahead.
Who are the witnesses that you have today?
We have Mr. Tees and then Mr. Cox.
Great, thank you.
Thank you, Mr. Cooper. And this is a good opportunity for the judge to state for the record the attendance of Chairman Scott Roop and Commissioners Jason Holzman and Kayla Hahn. Commissioner Maida Coleman is in knee surgery today and will be recovering. We wish her the best and we'll keep her in our thoughts. And I believe I have Commissioner Kolkmeyer on the WebEx. But we're pending on that. Okay, let's move on in our opening statements. Commissioner Kolkmeyer is also engaged in a medical appointment this morning, but he will be joining us later. I just received that information. Thank you. Let's move on to mini opening statements for staff. Thank you.
Thank you, Your Honor. Good morning. May it please the Commission. Today you're going to hear from Staff Accountant Keith Majors, who is going to explain why staff has taken the position that it has with respect to the costs that Confluence would like to recover. Not only recover, but put into rate base and receive a return on. As long ago as 2008, when a former electric company, KCP&L, purchased Aquila, there was a very comprehensive report and order issued by the Commission, and one of the things that report and order did was distinguish between transaction costs and transition costs. And the decision the Commission made in that order was that transaction costs could not be recovered and should not be paid by the ratepayers, while transition costs can be recovered and should be paid by the ratepayers. In fact, in that case, no one opposed the recovery of transition costs. So what's the difference between these things? Well, the transaction costs are costs that are incurred in order to complete the transaction. They include legal fees, they include engineering information, they include surveys, various reports, various types of professional involvement that is necessary for the transaction to go forward and be completed. Transition costs, on the other hand, are the costs that are incurred by the buyer in integrating the system into their network, their system. Now, in this case, we're talking about small water and sewer companies. There's not a contiguous water or sewer network that they're being integrated into, but they're still being brought within Confluence's system under its aegis. And so one of the common threads in this case is that these are all distressed and decrepit systems that are purchased. They all need significant capital investment and improvement to bring them up even to the minimum standard. So what staff is concerned about here is a little bit of blurring of the lines between transaction costs and transition costs. Clearly, for a company that, like Confluence, that's buying systems at an incredible rate of speed, the best thing for them is if the ratepayers are underwriting their purchases. They can stretch their dollars further if they're getting recovery of these costs from the ratepayers. So what staff requests that you do is listen very carefully to the witnesses and look for that distinction. Which of these costs are necessary for the transaction to go forward and be completed? And that includes the initial information that's going to drive the decision of even to go forward with the transaction, right? And then distinguish that from the transition costs, which are the outlays that are going to support all of the improvements that are going to be made to the system by its new owner, Confluence. Thank you. Any questions?
Are there any commissioner questions? Chairman?
Just high level, we can ask the witnesses, but did staff disallow any transition costs that the company had labeled as transition costs?
It's my understanding staff did not.
Okay, I'll ask the witness too. Thank you.
Thank you.
Thank you. And Mr. Kleiser?
Good morning, Commissioners. I will endeavor to keep this relatively short. I'm going to clue in on something that Mr. Cooper said with regard to the opening for Confluence Rivers. He characterized this as a drastic departure from what's happened in the past. And I actually don't think that that's true. Let's level set here. First of all, for every major rate case, for every large rate case dealing with a water company like Missouri American Water or a gas company or an electric company, staff is doing exactly what it has always done and what its precedent has always been set by this commission. They're doing what you told them to do in the past. So there's nothing really more to it than that. Now, there's a specific issue with regard to the past Confluence rate cases. And again, Mr. Cooper in Confluence tries to suggest that this is not how things have happened in the past, but that's also not true. The past two Confluence rate cases were settled by disposition agreement, which explicitly stated that there was no rate-making principles decided in the terms of the amount settled. In other words, they were black boxed. For Confluence to now come back and attempt to claim that dollar amounts included in those black boxes are specifically related to certain items is a violation of those agreements. Actually, it's not the first time you're going to hear today that Confluence violates its stipulation agreements or the commission orders to adhere to them. It's actually kind of a common theme for Confluence, but I'll wait for the next issue to bring that back up. Moving on really quick, what is the logical reason behind the precedent that's set here? Well, it's relatively simple. I think that actually Mr. Thompson has already done such a good job, I'm not really going to cover it very much, other than to point you to the statement that Mr. Majors includes in his surrebuttal testimony about how allowing these costs can cause an increase in creep in the overall rate base of the system if it changes hands multiple times without any significant improvement on the part of the customers, or sorry, for the benefit of the customers. That being said, when Confluence acquires a system and it does make improvements, those improvements are included. They are allowed to recover those and they start earning profit on them as soon as they come in for a rate case. So again, we're not trying to disallow anything other than the legal fees effectively that Confluence incurs in order to expand its business, something that its shareholders ultimately earn a profit for. Honestly, I actually don't have much else beyond those simple points, so I'm going to stop right there. Thank you.
Thank you, Mr. Kleiser. Are there any commissioner questions for Mr. Kleiser? Hearing none. Thank you, sir. Let's move on to our first witness, Confluence Rivers. Go ahead.
We would call Mr. Teese.
As Mr. Teese makes his way to the stand, I would remind him and those listening in the audience that Mr. Teese has already been sworn in, so he will not be resworn. However, he is still under oath. Thank you, sir. Go ahead and have a seat. I would also like to take this quick break to announce that there is a smell in the lobby. We do have an official accounting of what that is. In the cafe that used to be open outside, there was some grease blockage in a drain, and there are workers clearing that out. It should be aired out fairly soon, but I know that there was some discussion of that earlier, and I wanted to give the official response and give everybody some good news that that is not going to be permanent. Thank you. Go ahead with your witness.
Your Honor, well, please state your name for the record.
Brent Teese, T-H-I-E-S.
Your Honor, we would tender Mr. Teese for cross-examination.
Thank you. Let's go to staff.
Good morning, Mr. Teese.
Good morning.
Have you been involved with any of the staff-assisted rate cases that Confluence has brought?
I have.
And would you agree with me that those rate cases typically end with a negotiated disposition agreement?
I'm trying to remember. I know that the Confluence Rivers and Elm Hills cases did. The first one I was involved with was Indian Hills, which did not. And those are the three that I remember. So, 2-1, I guess.
Okay, great. Thank you. No further questions.
Mr. Kleiser,
No questions, thank you.
are there any commissioner questions for Mr. Teese? All right, the bench does have just a couple questions. I want to direct you to page 11 of your rebuttal testimony. The very first sentence, I'll go ahead and read the sentence. Once a particular system acquisition has been completed, it is the company's procedure to transfer amounts recorded in account 183 to construction work in progress, comma, and ultimately to the appropriate utility plant in service account, comma, for inclusion in rate base, period. Mr. Teese, my question is, what is the appropriate utility plant in service account? What do you mean by that?
Yeah, so there are a couple of concepts in play there, but ultimately, the USOA instructs that the company capitalize items to the utility plant and service account that is most applicable to the source of the cost. And so what we're talking about here generally is what might be considered an indirect capital cost, meaning it's engineering, but it's not the cost of a plant or a pipe, right? And so, however, what the USOA instructs is that you capitalize the indirect costs, like engineering, with the pumps and pipes that are the more firm or the hard cost, right? So what Confluence Rivers' management team has decided is that these costs, so for right-of-way and access, would be capitalized to the accounts associated with the collection or transmission system, because that's what we're doing, is making sure we have easements and rights-of-way to service the land area, if you will, associated with the systems.
Do you have a list of the acquisition costs that have been posted to account 183 and then account 107?
I don't have it in front of me. We have it in this docket, yes.
It's been filed?
It has, yes.
Can you direct me? It doesn't need to be specific, but was it attached to one of your testimonies?
It was in a data request that we submitted, requested by staff.
Okay. That is essentially a transaction between the parties, and the commissioners are not privy to that.
Okay.
Would you please provide that list as an exhibit? And I'll direct my requests now to counsel for the company. We had previously discussed a due date for commission-requested and/or late-filed exhibits a week from the end of the hearing. The last day is the 17th. That's a Thursday. The following Thursday is the 24th. Would that give you enough time?
I believe so. Yes, Your Honor.
Thank you, sir. The commission requests that as an exhibit.
Absolutely.
There are no more bench questions. I'll ask if there's any commissioner questions, and we'll go to cross-examination. Mr. Thompson.
No questions, thank you.
Mr. Gleiser.
Just briefly, so I want to make sure I understand this, and I'm gonna use as a specific example, let's say the cost that you pay a lawyer to draft the contract for an acquisition. Well, that's at least one of the examples of the cost that we're dealing with here, right? Can we agree with that?
I don't know of a specific line item that applies to that. Generally, we have in-house lawyers doing some things, and those would be business development costs. So there's a distinction there in our accounting procedure about where those go. So I can't say unequivocally no, but generally speaking, those we don't seek to put those in a case like this.
So the cost of acquiring, well, what's the cost of a clear title? That was one of the examples, right?
Sure.
So that would be the cost to a title company, for example, to do a title search?
I'm not sure all that goes in there, but potentially.
All right, so let's use that as an example then. So, as I understand it correctly, what you're saying is the cost of the money that you pay to the title company, that's going to be booked as basically pipe in the grounds?
It's going to be booked along with that according to the USOA instructions, yes.
So it's going to increase the value of pipe in the grounds,
Yes.
even though there is no additional pipe, right?
Yeah, I mean, there are no more feet of pipe as a result.
There's no more feet of pipe. Customers aren't receiving any benefit from additional pipe, correct?
I mean, customers are receiving benefit of the title, the access, and the professional operations, but there are no more feet of pipe. You're absolutely correct.
Right,
there.
so the customers don't receive any additional benefit for any more pipe, but they're going to pay for that pipe, and they're going to pay you profit on that pipe. That doesn't exist, correct?
The service provided and the access to those pipes is value. And so to say they're paying for nothing, I would not agree with.
But they aren't paying for the pipe. We're going to agree to that.
That's correct.
Okay. Thank you. I have no further questions.
Thank you. Redirect.
Yes, Your Honor, thank you. You were asked a question by Mr. Thompson concerning whether some of the staff-assisted cases are resolved by disposition agreement, correct?
Correct.
In those cases that are resolved by acquisition agreements or disposition agreements, are there still staff work papers that form the basis for the parties' work in those cases?
There are. The staff still does their full EMS run leading up to their report before negotiations begin, generally.
And when you made statements in your testimony about how this issue was handled in prior cases, was it based upon your review of staff work papers?
It was.
Real briefly, if you know, you were asked questions by Mr. Kleiser concerning sort of the title issues involved here. Do you have any examples of the title issues that the company has run into in some of its small company acquisitions?
I would object that it's beyond the scope of my cross-examination. I was using title as an example to get to how it's booked. I had no interest in knowing what the specific problems they were referring to are.
I'll allow it. Go ahead. Overruled.
That's a better question for Mr. Cox, probably. I know we have access issues, but those could be related more to easements and those kinds of things, so I would be slow to speak on that.
Okay. That's all the questions I have here.
Thank you, Mr. Teese. You are excused. Let's have Confluence call your next witness.
We will call Mr. Cox to the stand.
Thank you, sir. Please raise your right hand. Do you solemnly swear or affirm to tell the truth and the whole truth during your testimony today?
I do.
Thank you. Please have a seat. Your witness?
Thank you, Your Honor. Please state your name.
My name is Josiah Cox.
By whom are you employed and in what capacity?
I'm employed by Confluence Rivers Utility Operating Company as the president. I'm also the president of Central States Water CSWR LLC.
Have you caused to be prepared for purposes of this proceeding certain direct testimony, rebuttal testimony in both public and confidential versions, and surrebuttal testimony in question and answer form?
I have.
Is it your understanding that that testimony has been marked as Exhibits 4, 5, and 5C, and 6 for identification?
I believe it has.
Do you have any changes that you would like to make to that testimony at this time?
I do not.
If I were to ask you the questions which are contained in Exhibits 4, 5, and 6 today, would your answers be the same?
Yes.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, I would offer Exhibits 4, 5, 5C, and 6 into evidence and tender Mr. Cox for cross-examination.
Thank you. You've heard the motion. Are there any objections? Hearing none, the exhibits are so admitted. 4, 5, 5C, and 6. The witness has been tendered. We'll go to cross-examination. Mr. Thompson.
No questions, Judge. Thank you.
Mr. Kleiser.
No questions, thank you.
Any questions from the commissioners? Chairman.
Thank you, Judge. Good morning.
Good morning, Commissioner, Chairman.
Let's start here. In your council's opening, a lot of emphasis was put on if the company were to wait till the 51st day, then whatever the investment that they had made would be allowable. How much, I'm trying to draw, and I haven't seen the data request with the list of transactions, which maybe will help. So my question to you is, how much of the disallowed money, in your opinion, is from those investments that if you would have waited to the 51st day, we wouldn't even be talking about?
I believe almost all of these investments that we're talking about in this particular issue right here are needed just to run the system. I mean, I'll give you a great example. A number of years ago, there was a water utility that's north of Columbia, Smithview. The owner walked away from the utility, so left the keys hanging in the box and said, it's your problem, right? So the staff calls us, says, hey, when you take up this water utility, so think, in that example, can't get a hold of the owner. There are literally no maps of the utilities, no catalog of the specific assets that exist, no idea about ownership, easements, anything like that. So we immediately launch engineering and survey. We have to figure out, hey, where are all the assets? Where are the meter boxes? Where are the lines? You know, what does it take to run this system? How's the tower powered? Where's the well? All those kind of basic issues, which, by the way, we have to have from Missouri One Call. So, and that's a great example. Those are the preliminary engineering things that we're doing. We're mapping the systems, and then we're saying, okay, what do we have to address day one we buy this system? So this electric doesn't work, this pump is not working, I mean, you name it. And that's exactly what we do in the 35 transactions we've done in Missouri. It's basically 70 systems, 68 of them are out of compliance.
So when does the 51 days start? When you agree to purchase, when you close, so when does that 51st day come into play?
Yeah, so that was an artificial day that really the staff used to allow or disallow costs. So that 51 day has nothing to do with the way we keep our books and records. That was a cutoff period that the staff used. You know, from our perspective, we were doing all this work leading up to a transaction.
And when do they start that 51 day count? What is their day one? What do they consider day one? The
Yeah,
day
so
that you agree verbally to take or?
No. So this is the way I understand the staff has done it. It's the day from the day we close on the system. So I think we did all this mapping, engineering, all that before we close, because we have to have all the information before we close. Then there's day one. Then we're doing improvements immediately. Day 51, after we close, is the day they start reallowing engineering and survey costs, you know, title work, property work, all that.
So after you take ownership is when they are starting a 50-day delay.
That is my understanding.
So the example of like clean title, that has to be done prior to a closing, correct?
That's correct, Chairman. And it is shocking how much real estate work we have to do. How many of these owners don't actually own the assets, don't have any easements, have no legal access to their assets. All those issues have to happen before we close.
So the issue of, clean title that was used as the example is irregardless of the 51 days, since it wouldn't even be considered as a cost to the company post-closing.
There are occasionally costs that run over, so that we have to do, we've got a really bad title issue, a really bad or contested access issue. Those can last after day 51.
So you close on a property with a contested title?
We have before, not contested title of the assets, but contested access is what we've closed over before.
Access, okay. So in your opinion, I'm going to give you an example, and I want you to tell me how it's either right or wrong. When a person goes to purchase a home, they have title costs and things of that nature, which are done prior to the transaction. Usually you don't close on a home until you have clear title. But those costs are paid separately to a title company. Some will allow you to roll it into your loan, but they are delineated separate from the assets of what you are purchasing. Then if they were to sell that home, the next owners would have to do another title search before they close on the home, and thereafter. So there's no value assigned to the home because that work has to continually be done. So how is that not a transaction cost?
Yeah, so here's the difference that we would view it. There are exact title insurance costs, just like you're talking about. They're very specific. That you could say, hey, these are transaction-specific costs. So that makes, I understand. But when we're talking about $1.2 million, we're talking about the majority of that is mapping, engineering, naming the assets, the geotagging those assets, finding where the easements are, so the difference between in the house example you just gave me, if I actually didn't own the real property the house was on, getting real property attached to the house does have value and stays with the house forever. So that would
So will the data request in the list of the transactions delineate what was engineering costs and what was title costs? Will that be delineated for us?
we can delineate what exactly the title insurance costs are very specifically as a post.
I mean, to me, that would be helpful because since it was used as an example and stuff to try to help us delineate between engineering and what adds value and what is transaction. Because, I mean, I don't know if it was your council or staff, but this debate is over what is a transition and what is a transaction cost. And the more we can have information would be helpful.
Yes, sir.
Thank you.
Commissioner Holzman?
Thank you. Good morning.
Good morning.
I want to start with kind of a macro perspective. We had a lot of testimony on taxes in the last discussion. Could you tell us, as the president of the company, what is your business model?
Yeah, I mean, so our missions bring safe, reliable, and environmentally responsible water resources to every community in the U.S. And that every community piece is really key because it's these small communities have been kind of passed over for investment for decades. So our business model is to find communities that need us. So those are distressed, water and wastewater systems, and then to go through the process of purchasing those, rehabilitating those, and coming before the commission to get rates commensurate with the investments we've made in those systems.
So going into that model, you understand that there's going to be some lag between the time that you purchase the system and the time that you actually come in to make those rates reflective of what they need to be for the investment to make them up to code.
Yes, Commissioner.
So in our tax discussion yesterday, we talked a lot, or not yesterday, Friday, we talked a lot about the time that and I'm asking you now because we didn't have a chance to talk to you about it directly, but I think it's important for that issue as well to hear your thoughts on it. We talked about the fact that you may not pay taxes for a long time going forward because of the model that you have. When do you envision there coming a time for you to have to start paying taxes on the investments you've made?
I believe Mr. Teese testified on that. I think it's a number of years from now. So it's 3, 4, 5 years from now is when those NOLs, if you will, run out. I think our problem with which we've spilt a lot of testimony ink on is historically these rates have been normalized. I've got almost 10 years of doing business in Missouri. So when you understand the regulatory framework, it gives you further framework to do more investments. These are long-term investments. Think all these assets. I mean, we talk a lot here about the improvements we've made, right? Because we have to bring these systems back into compliance. And I'm very proud of our record in Missouri. I think we've taken 50 systems from non-compliance to compliance. We think we're the largest movement of domestic systems from non-compliance to compliance in state history. But all of these systems need complete replacement over a long time period, right? So every stick of pipe, every pump, so not just the investments we're making today, right, to bring these back into compliance, but it's the investments that need to keep these things running for a long period of time. So it's a very long time horizon. That's why we need a stable regulatory environment.
And when did you start acquiring systems?
I believe we filed our first case in 2014.
2014. So you're almost at the 10-year mark, and you've acquired 70 systems, and 68 of those 70 were distressed.
That is correct.
What's your 5-year outlook look like in terms of how many systems? Will there ever come a time when you've you've acquired enough, or is this something that you will continue to pursue? I asked the question yesterday, how many systems are there in the state of Missouri? Do we know?
Well, I think we talked earlier, there are 4,500 systems in Missouri that kind of fit this, and the vast majority of those are distressed. Really from our perspective, it's kind of different. We're a private solution to a very public problem. We're never going to solve all the problems in the state. We're just going to continue to make the dent that we can make. So in terms of how many systems we're going to continue to acquire, that's really just, how difficult. I mean, our problem is interesting, right? We go to owners, so like we've mapped every single water and wastewater system in the United States. And then we've gone to the states that have the highest amount of non-compliance, so the most systems that are not meeting, EPA and DNR regulations, and the highest amount of fragmentation. So which states have the most small systems? Then we go to owners of distressed systems, and sometimes they're referred to us by DNR, they're referred to us by commission staff, on and on. But it's convincing the owners that they need to get out of the business. It's really interesting, in rural Missouri, how many owners I've talked to that say, well, I don't believe EPA should be able to regulate me. I don't believe the commission has jurisdiction over me. I'm just, statements that seem absurd in a hearing setting like this, but it is true about owners. So really there's a learning curve and an enforcement curve, right? Because, if you're the Department of Natural Resources, every dollar in fines you take from an owner is a dollar that doesn't go back into the systems. So oftentimes they're slow to fine because they're trying to cajole the owners into investing. And then when the DNR realizes, hey, there are interested buyers, they'll ramp up enforcement because they know, hey, this system's not just going to disappear into the ether like receivership. We've seen systems languish for decades under receivership. So all those factors kind of come into play as we're going to buy these systems.
So it's taken about 10 years to get to 70 systems. There's obviously a lot of systems that are going to need help in the future. This is your first large rate case, right? Before, it's always been staff assisted.
That is correct, and we did that at the request of the staff.
Okay. And so I'm all of this is leading up to the real primary question I have, and that's about the incentive to do this. You obviously have been incentivized enough over the last 10 years to execute this business model that you have. We talked previously about rather the treatment of taxes and how that would occur would be an incentive or disincentive to invest in Missouri, rather it's your company or anyone else who would want to rescue these distressed systems. In your opinion, first, question one, is there enough of an incentive in terms of the profit motive to continue to invest in Missouri? And two, does the tax treatment incentivize or disincentivize that overall, benefit to the investment?
Yeah, so I'll start with your first question. So the answer to that is, up until this general rate case, I would say there was enough stable regulatory environment that we were incentivized to continue to buy these systems. I mean, one of the things we say around our company all the time, we love what we do. We don't run on love. We have to have profit motive on this whole thing. But it's interesting as you go through the details in this case. Since our last rate case, we've acquired 19 systems, and the Office of Public Counsel has requested a net decrease in revenue. So when you get outcomes like that, that definitely tells you that, hey, this state is not welcoming to the type of investments we have to make, right? So, and it is, even though it is about which states are attracting capital. So I've invested a lot more money in Texas, a lot more money in Louisiana. Some of that is a function of, hey, the owners are different people, so it's harder to get them to the table. But some of that is we understand how fast the investments we recognize, and there's a public policy associated, like, hey, we know that these systems need invested collectively, commission staff, environmental regulator, all of that, and we thought we had that here in this state. Frankly, in some ways, we may be victims of our own success. We bought, 20 regulated systems in the state of Missouri. A number of those, we've reduced receivership by like 80% in the state. So in some ways, you may not just feel the pain of it anymore because some of the worst systems are kind of gone. And so that may be one. On the tax issue, I would say, of course, being disallowed at all is a major disincentive. The methodology recommended by staff as a secondary option, we could live with.
Okay, thank you.
Commissioner Hahn.
Thank you. Just a few follow-up questions. You and your counsel previously mentioned that you're undergoing this rate case methodology, even though you may not qualify as far as size. How many customers are at issue in this particular proceeding?
I think it's 9,600 connections, which is houses, both water and sewer combined. That represents, I would say, 20,000 customers, just when you think how many people live in every individual house. So around that number.
And then how much exactly is, in this case, I think you might have mentioned 1.2 million, but the staff disallowance for transaction costs?
Yeah, about approximately 1.2 million in engineering, survey, and legal.
And then, do you ever conduct transaction costs for systems that you don't purchase?
No, we do. We have very little. First of all, 94% of all the owners we originally engage conversations with, we convert to contracts. So a very high percentage. We have a very low percentage of transaction costs, and we don't launch engineering, all of that, until we have a contract in place. So it's all done in house. So there's no expenses hanging out there.
Okay, so earlier when Mr. Teese testified that perhaps there could be, looking at systems that you may not purchase that could potentially be booked to business development cost and attributable somewhere else where ratepayers wouldn't be paying for it?
That is correct.
Okay.
Those expenses are, we don't try to recover those expenses.
Okay, that's helpful. That's all my questions.
Thank you, Mr. Cox. That's going to take us back to redirect. I do understand that we have, or I'm sorry, recross. I do understand that we have opened up some extra issues. So I'm going to be mindful of that and give the parties a little bit extra leeway here. But if we get too far afield on issues that are upcoming later on in the week, we need to be mindful of that too. Recross, Mr. Thompson.
Thank you, Judge. You told the chairman, I believe, that you incur costs, engineering, legal, title costs, what have you, necessary to run the system. These are necessary to run the system. Do you recall saying that?
I do.
And you further stated that we do all of this before we close because we have to have it before we close. You recall saying that?
I do.
And you just now told Commissioner Hahn that you don't incur these costs until you have a contract in place, right?
Correct.
So that kind of gives us a timeline, right? The contract's in place, you spend money on legal fees, engineering fees, survey, title corrections, that kind of thing. And when that's all finished and you've got the system to where you want it, then you close the contract. Is that right?
It's a little more complicated than that. So once we sign a contract, then we launch the engineering. So we think we're mapping the system, we're determining all the assets, we're going through, making sure they actually own the assets they say they own. And then we're simultaneously filing an acquisition case with the commission. So we're running these two processes in tandem. So as we're going through the acquisition case, because those can take 4 to 6 months, we're finishing mapping all the assets and tagging all the individual components of the system.
Okay. Now,
Mr. Thompson, could you please speak into the microphone? Thank
I
you.
apologize, Judge. Now, with respect to the distinction between transaction costs and transition costs, you said that one of the things you do is make sure they actually own all the things they say they do. Do you recall saying that?
I do.
And it would be unusual to purchase something without knowing exactly what it is you're purchasing. Do you agree?
I would normally agree, but in this business, that's not really the case because of how terrible the assets are and how little documentation.
Okay. If you find out that they don't own all the things they claim to own, do you then not close?
No, we put them in a holding pattern as we go through the process of getting title, going through the real property surveys, determine where the assets really lay, all of that.
Okay. So you mentioned Smithview as an example. So when did you first hear about Smithview? How did that come to be on your radar?
The commission staff approached us, I want to say it was 2017, 2016, at some point in there.
Okay, and I can certainly understand that. I remember Smithview very well. And so staff said, here's a distressed system, you might think about buying this one, something like that?
No, here are the keys, please run this.
Okay.
We don't know what to do. We can't get a hold of the owner, so literally we took the keys from the staff at the site. We had no contract with the owner, and we started emergency operations.
Okay. Would you agree with me that that was an unusual acquisition?
No, I would say we've had a number of acquisitions of emergency. I think Robertsville, I think a lot of these, a lot of the receivership systems were in similar levels of disrepair, where no one knew where anything was. A lot of the DNR systems that we're doing emergency operations on the front end. So it's decently typical across Missouri and across the country.
Okay, but it's not every system you've acquired, is it?
It is not every system, correct?
Can you give me a percentage?
A percentage of what?
A percentage of the systems you've acquired, what percentage of them would you say were acquired on an emergency basis like Smithview?
I don't know. I had to think about that. I don't know off the top of my head.
Okay, I have no further questions. Thank you.
Mr. Kleiser?
Good morning.
Good morning.
Let's start by just cleaning up the record a little bit on a couple of points. You were asked a question by the Commissioner Hahn. I was about to say Holzman because I was reading the names. You were asked a question by Commissioner Holzman regarding the amount of the disallowance, and you said about 1.2 million, right? Do you recall that?
I do.
But that's 1.2 million of plant, correct?
That is correct.
And what we're actually disallowing here, the effect on the revenue requirement would be the plant multiplied by whatever rate of return the commission orders, correct?
That is correct.
So if we just assume hypothetically a 10% rate of return, we're really talking about a $120,000 disallowance.
I agree with you.
Okay, just want to make sure that everybody understood the actual amount in question here. Next, there was a discussion on the number of water customers, and you said about 9,600. Is that right? I'm not sure if I got the number right.
No, I meant water and sewer customers combined.
Okay, so that's the point I think I want to get clear here. If I'm a Confluence water and sewer customer, how many times are you counting me for purposes of getting to that number?
Yeah, twice. Once as a sewer customer, once as water customer.
Okay. All right, so if we were to count the people who get both water and sewer as just one, the actual number of customers you serve would be much lower.
I think what we're talking about is the difference between connections and customers. So connections are a house, customers are the people in the house. So DNR says it's 3.5 customers per house, and that's where we get the general customer counts that we use.
I'm not talking about the number of customer counts. I just want to make sure that we understand how many different connections are you serving. If you connect a house for both water and sewer, you're counting that as two different connections.
That is correct.
And the staff small assisted rate case, I believe the cutoff limit is 8,000?
It's 8,000 of currently, it's 8,000 of an individual type of connection. So you have to be 8,000 water or 8,000 sewer, which is what came up in that. Yeah, that's it.
Okay. And there was discussion regarding a net decrease by the OPC, and I just want to make sure. I understand that OPC and company disagree over whether or not this is correct, but OPC's argument, you would agree with me, is for $1 million decrease in an expense item, correct?
No, the overall revenue requirement that OPC is requesting is lower than our current rates.
I agree with you. That's not my question. Let's be clear here. The 1.6 million that we're referring to that we take $1 million off of, that's for contractor, third-party operations, right?
1.6, I'm sorry, could you say that again?
The OPC's recommendation is based on taking $1 million off the 1.6 million spent on contract party, third-party operators. Third-party contract operators. I'm saying that confused. Let me start over.
Judge, let me inject, I guess, an objection here for a minute. I think we're getting into detail on an issue that's coming up on the schedule and that Mr. Cox will appear on in the future, but.
Let me back off the question. It's not really important. Our All right. Let's talk about the incentives discussion that you had with Commissioner Holzman. Now, I assume that you're aware that there is a rule in place for acquisition incentives for small water rate cases, correct?
I believe that's true. I don't think it's ever been used in the state.
You don't think it's ever been used in the state?
Not that I can remember.
So you don't recall when your company made a request for an acquisition incentive?
We did, but we didn't end up getting it.
I know, but let's go through that. So the first time that you made the acquisition incentive case, do you remember which case that was?
I do not.
That would be the Osage case. I'll go ahead and ask for an exhibit to be marked. It should be 216, I think. Someone correct me if I'm wrong.
So marked. Mr. Kleiser, what is your under 10-word description?
Amended application and motion for waiver for case WA 2019-0185. No, that's the right thing. I didn't keep a copy for myself. Are you familiar with this, Mr. Cox?
Look, what exhibit number did this end up being?
I believe 216.
Yes, that's correct.
Okay. And then returning to this, are you familiar with this, Mr. Cox?
I am.
Right, and this is a request by the Osage Utility Operating Company, right?
That is correct.
And you would agree with me that that's one of the predecessors to Confluence Rivers, correct?
Correct.
And that the Osage Utility Operating Company was one of the companies that are ultimately combined to form the current Confluence Rivers, correct?
It was consolidated, the assets were consolidated underneath Confluence Rivers, correct.
And if you'll turn to page 14 in the document, you would agree with me that this document includes a request for an acquisition incentive, correct?
I do.
And I think you already said this earlier, but let's reconfirm. The commission did not grant the acquisition incentive in this case. Do you recall that?
I don't remember if we withdrew it, or I don't remember the details.
But you would agree with me that it wasn't granted.
Yes.
Now, at the time of this acquisition, I think you had about 20 systems in the state. You agree with me that's fairly close?
I don't recall.
Well, let's say at a minimum, we can agree that this case was from 2019, correct? Just using the number at the top.
Yes.
Now, you've gone on to acquire quite a few systems since then, haven't you?
Correct.
Which means that you've been able to acquire quite a few systems in the state without receiving an incentive from this commission, correct?
Correct. Under a stable regulatory environment that we thought we understood the rules of the road. Yes.
Yes, but to simplify the answer, you've acquired quite a few systems in this state without receiving an incentive, correct?
We've acquired systems after this without receiving incentive.
Was this the only time that you requested an incentive?
I do not recall.
Your Honor, I'll go ahead and mark another exhibit. This would be 2017.
So marked.
And because Your Honor is going to ask, this would be the application and motion for waiver that was ultimately for case WM 2020-0403. However, the docket number does not appear on this document. Mr. Cox, are you familiar with this document?
I am.
And you would agree with me that this was the application for Confluence Rivers to acquire the Terre du Lac system?
I agree.
And you would agree with me that on page 7, there's again a request for an acquisition incentive?
I agree.
Now, do you recall what happened in this case?
I do not.
I'll just go ahead and mark another exhibit. Should be 2018 at this point, correct?
218, yes.
18, sorry. This will be unanimous stipulation and agreement, same case number as previous. Mr. Cox, do you recognize this document?
I do.
You would agree with me that this is a unanimous stipulation agreement resolving the acquisition of the Terror system by Confluence Rivers?
I do.
And you would agree with me that if you turn to the stipulation beginning on page 2 and look at the last item, which is number 5, appearing on page 4, it reads, "The signatories acknowledge that Confluence has withdrawn its request for an acquisition incentive?"
I'm sorry, could you point to me the area again?
Of course.
What page?
Stipulation beginning on page 2,
Okay.
but the line is number 5 on page 4. So specifically, it's line 5 on page 4.
I see it now.
And you would agree with me that it says, "The signatories acknowledge that Confluence has withdrawn its request for an acquisition incentive."
I do.
So you would agree with me that twice now, Confluence has come to this commission requesting an incentive to continue acquiring systems. Twice now, it has not gotten that incentive, and yet the company continues to acquire systems in this state. Is that correct?
I believe that's correct. I think we realize that a 1 percentage point ROE difference in a contested acquisition case, the costs are prohibitive.
Regarding the type of costs which are included in the acquisition issue at hand, I want to be general. Does that include costs that Confluence incurs to bring its CCN application?
I don't know the answer to that question.
Do you have a copy of the rebuttal testimony of Mr. Thies?
I do not.
You got it? Okay. I believe one's being provided, so I will just wait a second.
I now have it.
Can you turn to page 10 of his rebuttal testimony for me?
I have it.
On page 10, lines 11 through 12, it reads, "And the cost to appropriately file required acquisition documents with the commission." Would you agree with me?
I do.
And he is referring to the costs and expenditures that allow the company, sorry, apologies, I'm having problems all of a sudden. You would agree with me that the costs that he's referring to are the ones that are being included in this acquisition issue at hand?
Yes, I agree with that. And some of those are transfer of CCN, some are creating a new certificate area.
You would agree with me that every time a system is transferred, the company requesting transfer has to file a rate case? Sorry, not a rate case, a case with the commission?
That is correct.
So legal fees would be incurred by any company seeking transfer of an asset, correct?
Yes, whether or not it was unregulated or regulated, yes.
I have no further questions. Thank you.
Thank you, and redirect.
Thank you, Your Honor.
Can I put away this testimony?
Your Honor, I would move for the admission of 216, 217, and 218 before I forget.
I understand that you use these to refresh the witness's recollection. Can you tell me why you want to introduce these as evidence?
Ooh, you are going to ask an interesting question in as far as I personally have always taken the position that the commission's records is something the commission should take administrative notice of at a minimum and shouldn't actually require to be entered into the record because it's part of the commission's overall record. So to establish the fact that to establish the facts that we discussed is my ultimate answer to your question. However, if the commission would prefer to simply take administrative notice of its past orders and the contents of its own files, I'm happy with that as well.
Are you going to cite to these?
Yes. To
Okay.
establish the question of the incentive, which is the purpose of our discussion, yes, I intend to cite to these, whether they are exhibits or whether I'm citing to the records.
I don't need any more, I'm convinced. Any objections?
No, Your Honor.
Seeing no objections, all three, Exhibit 216, 217, and 218, are hereby admitted onto the hearing record. Mr. Cooper.
Mr. Cox, let's start with the subject of those documents that were just admitted into evidence. The incentive that is referenced in those documents is a very specific incentive, isn't it?
It is.
And the basis of that particular incentive is a regulation.
That's correct.
And when we generally talk about incentives for the company or disincentives for the company, is it more of a general discussion than that particular regulation?
That is correct. I don't even think about that particular regulation when I think about incentives to invest.
Mr. Kleiser was kind of clarifying the $1.2 million plant number that had been referenced in your testimony. I think it was also, I know it was also referenced in my opening, and pointing out that it is, again, it's a plant number, correct? Not a revenue requirement number.
Correct.
And he asked you about the revenue requirement impact generally. But in addition to the revenue requirement impact, is there a write-off issue that also arises if these costs are disallowed in this case?
Yes.
And how does that impact the company?
I mean, it impacts us in twofold. One, it is another tax issue, and another, it's telling us these costs are not reasonable.
Something that you would take into account on a going-forward basis?
Absolutely, especially as we're buying these stress systems that lack basic books and records, maps, inventory of assets, all of that.
You got into a conversation about connections versus what you think of as customers with Mr. Kleiser. Going back to kind of where we started this, number of connections combined, water and sewer, are about how many in Missouri?
I believe about 9,600.
Okay. And at least, well, I don't remember the exact breakdown, but it's closer to 50-50 in terms of water versus sewer, isn't it? But
I believe it's skewed towards wastewater.
in any case, neither water nor sewer would exceed 8,000 connections, correct?
Correct.
I don't have any other questions, Your Honor. Thank you.
Thank you. Thank you, Mr. Cox. You are dismissed. Staff, go ahead and call your next witness.
Thank you, Judge. Staff calls Keith Majors.
Thank you. And Mr. Majors, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth during your testimony today?
I do.
Thank you. Please have a seat and your witness.
Thank you, Judge. Please state your name and spell it for the reporter.
Keith Majors, Keith Majors.
Thank you. How are you employed, Mr. Majors?
as a utility regulatory audit unit supervisor with the Missouri Public Service Commission
And where is your workstation?
in Kansas City, Missouri.
And Mr. Majors, did you prepare or cause to be prepared exhibits that have been marked as 110, 117, and 129, public and confidential, being direct, rebuttal, and surrebuttal testimony?
Yes.
And are those items, well, first let me ask, do you have any corrections?
No.
Are those items true and correct to the best of your knowledge and belief?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
At this time, I move for the admission of Exhibits 110, 117, 129, public and confidential.
You've heard the motion and the exhibits numbers. Are there any objections to the admission of those exhibits onto the hearing record? Hearing none, they are so admitted. Go ahead.
Thank you, Judge. I tender the witness for cross-examination.
Mr. Kleiser.
Good morning, Mr. Majors.
Good morning.
Do you have a copy of Mr. Thies's rebuttal testimony before
I
you?
do.
Can you turn to page 12?
I am there.
Would you agree with me that on pages 8, sorry, I keep saying that, lines 8 through, oh, the one I want is up through 11. Mr. Thies is referring to two rate cases where he claims the company can confirm that acquisition costs of this type were included in past staff-assisted rate cases.
Yes, I see that.
And I'm sorry to make you jump around, but turning to your surrebuttal testimony, you provided a response to this, correct?
Yes, I'm sure I do, but let me get to there. I've got my surrebuttal.
Specifically, I'm referring you to page 8, lines 10 through 19.
Yes, I'm there.
And I don't mean to paraphrase you. Well, I'm going to paraphrase you. I'm hopefully doing it correctly. But effectively, your position is that those disposition agreements most likely contained agreements that they weren't necessarily binding with regard to the specific. Help me out here. What were you trying to say there?
Well, I think that in the small water case process, there was some of the similar costs that were included in not only these systems, but also Hillcrest and what I'll call legacy Confluence systems. But those were in the context of a disposition agreement, which is much like a stipulation agreement. I wasn't a party to those and wasn't involved in the cases.
That's good. Thank you very much. I'm actually going to go ahead and continue to ask things be marked, so we should be at 219 now, correct?
Yes.
Not sure if it matters which order, but the first one will be the disposition agreement for case WR 2020-0275.
Thank you, sir.
I did it this time. I'm learning. Can you turn to the last, well, first of all, let's identify this document. You would agree with me that this is the non-unanimous disposition agreement regarding disposition of small utility company revenue increase request for Elm Hills Utility Operating Company?
Yes, I reviewed this as part of staff's audit, and particularly these costs.
And you would agree with me that under the additional matters section found on the last page, which is not numbered, but it's the last one with words on it, it reads, other than the specific conditions agreed upon and expressly set out herein, the terms of this disposition agreement reflect compromise between OPC and the company, and no party has agreed to any particular rate-making principle in arriving at the amount of the annual operating revenue increase specified herein.
You read that correctly.
And you would agree with me the purpose of that provision is to prevent any party in future from attempting to rely on the amounts agreed to in this to set some kind of precedential value for this case.
Yes.
We'll go ahead and mark another exhibit. Nope, put those back. This is, again, unanimous agreement regarding disposition of small water case, et cetera, for WR 2020-0053. One for myself. Mr. Majors, can you identify this document?
This is the unanimous agreement regarding disposition of small utility company revenue increase request. This is the disposition agreement for, I think this is what I'll call the legacy Confluence systems, Auburn, and there's probably 10 others in there.
And on the additional matters, again, this time it's on page 3, although unnumbered. That first paragraph you see is substantially the same, although I believe the word staff has been inserted. I won't bother reading into the record again. You would agree with me that it's substantially the same, correct?
Yes.
And so once again, we have an agreement whereby the parties said, we are not going to agree that any specific rate-making principle is being adhered to here.
Yes.
So there was no agreement at all between the parties when these cases were settled that specific acquisition costs would or would not be included in rate base.
I think that's the general premise of the agreement.
All right. I will this time remember to move for the admission of 219 and 220.
Judge, the only clarification I guess I'd like to make is that commonly these agreements have attachments that are associated with them. So for example, on, I think it's the 220 document on the last page, there's an assortment of attachments that are a part of this, as long as we're considering those attachments to be a part of what we're able to reference and what's coming in with 219 and 220. I don't have any objection.
The documents, if you include the attachments, gets to like 170 pages, and our printer is having enough trouble as it is.
And I certainly am not asking for those pages. I just want to make sure that that what we're admitting is that entire package.
The judge has heard the combined request to admit Exhibit 219 and 220 and take administrative notice of the various attachments thereto in the official EFIS record. Any objections to the admission of those two exhibits? Hearing none, they are so admitted. Go ahead.
All right, thank you. So let's have a quick discussion on some of the types of costs that we're talking about here. You reference in your rebuttal, Mr. Thies, I hope I'm pronouncing his name correctly, rebuttal testimony when he identifies those costs. Do you recall that?
Yes.
So the costs that we're talking about, we have, let's break them down. We've got some engineering costs, we've got title costs, and we've got basically the cost of filing a CCN. Is that a fair way that we can break that down?
Yes, I have the, some information on the breakout that's being referenced. I think it's going to be filed with the commission on data request 66. So I
Well-
can provide some detail on that.
I assume the commission is just going to ask for it, so can you just tell us what the breakout is?
So there is, first of all, there's some discrepancy between the numbers. Mr. Thies's testimony is, if you'll pardon me a moment. Okay, so Mr. Teese has 1,218,969 listed in his rebuttal testimony. In the response to data request 88, which had all the plan improvements, I identified 1,204,907 in acquisition costs. And that was a data request for all plant improvements. The specific data request on acquisition costs, which is DR 66, lists $987,852. So about a $225,000 discrepancy on costs that aren't in this data request, that aren't delineated. But I can go through the costs that I can identify, if you'd like.
I think, even if I didn't ask what the commissioner almost certainly would, but before we get to that, I want to make sure I understand. Who's DR 66? That's to whom, from whom?
That would be staff data request 66 from the staff to Confluence Rivers.
Okay.
And in the same token, data request 88 from staff to Confluence Rivers.
So the 980 number, and again, I'm rounding here,
Yes,
was the Confluence's number reported to staff.
on specific acquisition costs, yes,
Okay. And then you said you can break down that 980 number.
yes.
If they'll permit me to continue asking open questions, because again, I feel like this is a point that the commission will want to ask, can you please give us that breakdown?
So in the description line, you have engineering-survey of $1,195, engineering-admin, $208,525, engineering-GIS, $59,828, engineering-survey, $165,158, legal-real estate, $430,667, legal-regulatory is $114,272. There's a blank on the description, so that would have to be by vendor, of $8,207.
Now, you read those off relatively fast, and it is not my intention to attempt to confuse the record. But what I heard was roughly $500,000 legal, the rest falling into the engineering category. Again, I'm doing my best. That's what I thought I heard. Am I wrong there?
No, that's relatively accurate. Pardon me one moment, this isn't my calculator. I've got $544,939 in legal costs, and that's a breakdown of $430,667 of legal-real estate and $114,272 legal-regulatory.
Okay. Now, is all that breakdown in staff DR 66?
So, the staff DR 66 response is, I believe, a one-tab spreadsheet with lots of lines. And what I've created are what are called pivot tables to summarize the data. So those totals will be right. I think that would be quite a lengthy process to take that spreadsheet and manually add each line. So for my convenience and the commission's, I've added those in a pivot table and separated the data.
Your Honor, this is gonna be a bit unorthodox, so bear with me here, because I think this is going to align with what I imagine you were going to do anyways. But I would imagine that this document that Mr. Majors has created is something the commission would like to have. And so I don't know if this is what you intended to make a commission request, or if I can move for it to be an exhibit. How best would you like to proceed with that?
Let's see if you get any objections. Any objections to the admission of,
It would be 221 if it was an OPC exhibit, or if staff would like to make it an exhibit since it's their work paper.
I don't mind if it's yours.
Fine, then let's call it 221 OP exhibit.
221 work, are we going to call these work papers associated with DR 66?
I can certainly print off another copy. It's saved. It's taking the data from DR 66 and,
Nope, you're already in. I just need the title of it.
staff data request 66 summary.
And so the one trick here is that you've tasked the parties with sending you the exhibits by email, and this will not be a document that I currently possess. So I will
Mere
ask-
details.
Okay, I'm going to move on then.
Any objection? No objection, so admitted. Mr. Majors, would you please be in contact with either Mr. Kleiser or your counsel to figure out how to submit this exhibit outside of our session today?
Of course.
Thank you, sir.
Okay, so I think I only have a handful of things left, really quick. Those legal fees that we were kind of in that table, about 100,000 of that was related to the cost of bringing CCN applications. Is that right?
Yes.
And you would agree with me that every time a system is transferred, you're going to have to request some kind of CCN application?
Yes.
And the 400,000 of that was cost for acquiring title?
Title, and I believe Confluence has referenced right-of-way establishment, things like that.
And you would expect that that would be a cost incurred every time property is transferred, correct?
To some extent, yes.
Is that part of why you would characterize those costs as a transaction? I had a mind blank for a second, which, that's why those were transition costs, correct?
I would categorize them as transaction costs.
Okay.
They're related to the change of ownership and establishing, I think, as Mr. Cox and Mr. Teese said, who owns what the assets actually are.
Okay, so just to clarify the record, because of my screw-up, you identify those as transaction costs?
Yes, correct.
Okay. One last thing. Any plant investments that were made to bring a system back online, for example, putting a new pump in, et cetera, would those fall into either transaction or transition costs?
I don't believe so. No, those are costs of plant improvements that provide utility service.
And that doesn't matter if it would happen within the first 51 days or not? If it was in that first 51 days, it would all be plant improvements?
No, I think that, well, if it was related to a distinct plant improvement, it's really not categorizable as a transaction cost or a transition cost or a cost of acquisition.
And those aren't included in the breakdown that you have? There's no direct plant improvements?
No, none that I'm aware of.
Actually, I lied about one last thing. I apologize. You would agree with me that there is a way that you could potentially recover costs that were deemed transaction costs outside of rate basing them, correct?
Yes, I think that by the same token, we've had these other systems. I think some of them have had rate-based treatment, some of them haven't for these costs. I think we would be more open to doing some kind of perhaps an amortization like the other systems, but I think they're certainly not directly categorizable as plant costs. Certainly, they're prudent, reasonable costs to that were incurred to acquire the systems to eventually make improvements to the system.
So if I understand you correctly, your ultimate recommendation is to not allow these costs to be included. But if the commission were to allow recovery of these costs at some level, a secondary recommendation would be to have them be amortized instead of rate-based.
I think that would be a fair conclusion, considering we have allowed some amount in prior cases, and as can be heard from the testimony of the company, these costs were incurred in efforts to acquire these systems and get them operating in compliance.
If the commission were to order an amortization, what would be the proper amortization period?
Well, I think part of our consternation about including these as plant items is that the plant items they were capitalized to, collection, sewers, distribution lines, things of that nature, can have a 50-year lifespan. I don't think it's certainly not fair to the customers who really these costs they're not plant costs. And so I don't think it's appropriate to include them on a 50-year lifespan and get rate-based treatment for the next 40, 50 years. I think perhaps 5 years is a non-arbitrary number. When you look at other acquisitions in the state, we've had a 5-year amortization of transition costs, not transaction costs. And so I think that might be an appropriate amortization. Certainly for one or two of the other systems that these costs were allowed, it was a 5-year amortization.
You were in the room earlier when Mr. Cox was testifying, correct?
Yes, I was.
And he referenced a tax write-off that would occur as a result of your disallowance. Do you recall that testimony?
I do.
Do you agree with his testimony?
I think that if you were to take staff's approach and completely not include these costs at all, that's a fair assumption that you would write off those assets.
And Mr. Cox provided an example of a situation where the company had to perform work because somebody had, I think, left the keys on the door, was kind of the way it was described. Do you recall that?
Yes.
I might have missed the name of that. What system was that?
Smithview, I've got to.
That's okay. I just wanted to know the name for now. Is Smithview what you would consider to be a fairly typical example of the acquisitions that Confluence undertakes?
Having not been intimately familiar with all the acquisitions, I think that's a fair assumption that I have no reason to dispute that the majority of Confluence's acquisitions are distressed systems.
What is the situation that Mr. Cox was referring to where there's no information whatsoever and no one to contact? Do you believe that's typical?
I think I recall his testimony being it's not atypical, so I have no reason to not believe that.
All right. I have no further questions. Thank you.
And Confluence.
Thank you, Your Honor. There were some questions from Mr. Kleiser about, it was related to the title work. And I think he suggested that title work would have to be done in every case. Is that generally your memory as well?
Yes.
If that title work involves straightening out title so that it's clear who owns it and it's clear that Confluence Rivers owns it going forward, or it involves the acquisition of an easement for access to the property, aren't those things that will be a benefit in the future and would not have to be redone in the future?
I think the latter would be acquisition of an easement for sure. That would go on to benefit the company. I think I would consider those, if they were categorized as acquisition costs. I really don't think a new easement for an acquisition, that's really not an acquisition cost. So I think in those cases, those may have been miscategorized.
But certainly there's something that would benefit the system on a going forward basis, correct?
Yes.
Because I don't have DR 0066 in front of me, what time period is staff asking about in that DR?
That's a really good question. I really don't recall. If I were to hazard a guess, it would be from the last Confluence case forward.
So if there were any amounts left over from prior cases on the company's books, they wouldn't necessarily be shown in a response to that type of data request or that time period, correct?
Right. There's, 225,000 is a pretty substantial gap. So, I mean, that would have to be remedied. Yeah.
And I think I heard you say a couple of times that you acknowledge that these types of costs had been included to some extent in the prior staff-assisted rate cases for the companies, correct?
Yes, I went back and researched, after watching Mr. Woodsmall's opening, the 5 cases that were referenced in in his opening concerning these costs.
Okay. Now, I want to go back actually to where your counsel started in his opening statement. And in your testimony, you cite Commission Case EM 2007-0374 in regard to the treatment of transition and transaction costs, correct?
Yes,
And again, as your counsel said, I believe, that case involved the proposed merger of Aquila Inc. and then entities ultimately associated with Kansas City Power and Light, correct?
yes,
And those were both large, then operating regulated electric utilities at the time of the merger, correct?
yes,
And then you further cite, I think, in your surrebuttal testimony to case number EM 2000-292.
yes, that was the St. Joe Power and Light purchase. Yes,
And by Utilicor, correct?
yes.
Which was a earlier name of Aquila, correct?
One of their many names, yes.
And again, both those entities were then established, regulated electric corporations, weren't they?
Yes,
And really, all 4 of those entities that we've mentioned were being traded on the stock exchange at the time, correct?
yes.
Now,
Or their parent companies.
Now, the quote you used from the St. Joseph Utilicor case includes the following. It says, "The net original cost rule was developed in order to protect ratepayers from having to pay higher rates simply because ownership of utility plant has changed without any actual change in the usefulness of the plant." Do you see that?
Yes,
Would you agree with me that in almost every, if not every, Confluence Rivers acquisition, the usefulness of the plant to be acquired is in question at the time of acquisition?
likely.
And certainly true in any existing system that's in a receivership or is saddled with DNR violations, correct?
Yes,
Now, on page 5 of your surrebuttal, you state that any costs related to the filing of an acquisition case before the commission are owner's costs, as there is no benefit to ratepayers for these costs, and these costs are not required for utility service, correct?
yes,
Now, when you say acquisition case, are you referring to merger cases under section 393-190, such as the St. Joe Utilicor or KCPL Aquila cases that you've cited?
No, I think those are really related to the legal work for the CCN case or the acquisition case, or there have been several, I would call them technical merger cases that Confluence has filed to consolidate rates. And any of those before the commission to acquire assets would be under the legal regulatory costs. And those, I can't recall any time those have been capitalized or deferred in any way. And so I think that's the clearest example of costs that really are ownership costs.
Well, let's start with that a little bit, and it gets toward, or this question will get to a little bit of what you were saying there, which is technically, other than the case where Confluence merged with Osage and Hillcrest and Indian Hills, its companies have not been involved in any true merger cases, have they, for acquisitions?
I think they've been legally structured as asset purchases. And so, yes, I would agree with your statement.
And in addition to the purchase of the assets of an existing regulated company, they also have cases where they've purchased assets from a homeowners association or some entity that's not regulated, correct?
Yes,
And they also have purchased some assets from some entities that perhaps should have been regulated, but have never either been, have never been brought into the fold, correct?
Yes.
And in those latter two types of cases, the function or the acquisition case really takes the form of a basic initial CCN case, correct?
Yes.
Because neither of those examples does the existing utility have a CCN, correct?
Yes.
And so in those instances, Confluence Rivers goes for a new CCN pursuant to section 393-170, correct?
I'm going to take your word. That's the right section of the rules and regulations, but sure. Yes.
Okay. And in those instances, the CCN is required for the provision of utility service, isn't it?
Yes.
Okay. And perhaps in the future, getting another CCN will not be necessary, correct?
Oh, for those systems that were purchased, I don't think you would need another CCN or anything like that.
Now, you also recite definitions of transaction and transition costs used in the KCPL Aquila case, correct?
Yes.
And the definition of transaction costs includes the statement that they are not to facilitate the provision of utility service, correct?
Yes.
And it also includes the statement or also states that transaction costs are not used or useful nor necessary for the provision of safe and adequate service, correct?
Yes.
Now, would you agree with me that the steps necessary for Confluence Rivers to acquire the assets of small, distressed, hold on just a second. Small distressed water and sewer utilities ultimately facilitates the provision of utility service and aids in the provision of safe and adequate service as to those systems?
I think as a general premise, yes, the transfer of ownership prior to the acquisition and post-acquisition, there's an definite improvement in safe and adequate service, no question.
Did staff make any attempt to determine whether the individual costs that it disallowed facilitated the provision of utility service or aided in the provision of safe and adequate service?
No, I think that following the commission's general rule on these kind of costs, that was really the genesis of the questioning of why these were capitalized, and so the removal from capital, that's really what justified it, in my mind.
And without any sort of detailed examination of the particular costs?
No, I think we had the response to data request 66, so they provide some detail, but I think as the big picture has been discussed, the commission has routinely denied pre and immediately post ownership transfer costs as transaction costs in both the examples that were in my testimony, the St. Joe merger and the acquisition of Aquila.
And I take it from that because it sounds like, let me confirm this first, that it's generally testimony and a position taken as a result of just the normal transaction rules, as you said, that were found in the two cases we've talked about, correct?
Right. Yes.
So any steps such as, going to the engineering department and talking about, what usefulness there might be to surveys or mapping or anything like that wouldn't have taken place?
No, I can't say they did.
Okay. That's all the questions I have here.
Thank you. And before we ask for commissioner questions, I just wanted to note that we will be ending for lunch after the conclusion of Mr. Major's testimony. Are there any commissioner questions? Chairman?
Thank you, Judge. Good morning.
Good
Still
morning.
Still morning. Ba-dum, ba-dum. The DR 66 and 88 that you have referenced, were any of those data requests the ones that were difficult to get information from the commission, from the company, that worked its all the way up to the agenda where we had to make a ruling on compelling?
No, neither one of those were, from my recollection, not at issue on a discovery dispute.
Thank you. You saved me from going back through agenda notes to look and see if those were one, because we had quite a few of those in this case. Secondly, during a staff-assisted case, would these costs that were uncategorized or maybe generally categorized, would those have been worked out with the company to properly categorize them, working with the company during a staff-assisted rate case?
I think so, and from just the work papers and the materials that I reviewed, we have been relatively open in the cases that they've referenced, the 5 cases, of including those costs with looking at the invoices and categorizing them. I think for the majority, they've been more of 301 or 303 organization costs. In 2 cases, they were included in the plant and service accounts. Does that answer your question?
Yes, so if staff is working with the company through the assisted rate case process, there's more communication back and forth. Well, let's put this one here, and you end up with maybe a better classification of actual costs into different accounts.
Yes, I think it's a fair statement. I also think that the distinction here is we have agreed to reflect those costs in cost of service. It wasn't a blanket proposal to wholesale defer all acquisition-related costs, such as is the case here. I don't think that's really that's really not an appropriate way to approach the issue. I think it's really on a more of a case-by-case basis and determining really which costs are ownership versus these costs have some kind of future benefit. We could come up with some kind of amortization for those, but not include them in plant.
So is this issue boiling down to the company is now going through a regular rate case where there's not the amount of communication between staff and anything that is unclear, staff may be erring on the side of declining or not including because of ambiguity in what cost and what should be categorized this?
Yes, I think that's a fair statement.
Okay. And how long you been with the commission?
16 years.
All right. You're a great American. We appreciate you.
Thank you.
You've seen a lot of black box settlements in your day.
Many, yes.
We've had a lot of discussion about, black box settlements and my impression and the company's impression. And I recall on several occasions asking companies questions about the black box settlement and being told, well, your answer will depend on who you talk to. Or we can't really calculate that. It just kind of depends on your position. So in these black box settlements, is it fair to say that one party may be viewing things a certain way of how they got to a resolution and the other party viewing it differently? But in the big picture thing, it's like, yeah, we're good. We're just going to move on.
Oh, absolutely. I think if you asked 5 different parties, you'll get 10 different answers about what was in this number, what was in that number, how did we arrive at this figure. I think it's very ambiguous.
So the statements that that everybody has had in all their cases, that this does not spell out any agreement to any type of a rate casing principle, is more put in there to reflect that ambiguity and differences of viewpoints of how you got to where you got.
Absolutely. And I think parties have relied on that language to go back and say, we're going to relitigate X issue because we didn't have a definitive answer or definitive rate-making treatment in that rate case or proceeding.
Okay. Great, thank you for your testimony. Thank you, Judge.
Commissioner Holzman?
How did you come up with the 50 days?
That's a very interesting question. I think the 50 days has really been incidental to the invoice dates that were on the data request response. I didn't come up with some kind of arbitrary 50-day cutoff. In fact, I'm really curious as to how they came up with the 50-day cutoff. My only guess is that that's the invoice date on 50 days past the closing date of some of the systems that got charged acquisition costs.
Okay, so do you think that it'll be 50 days in the next rate case?
No, I think we would look at whatever costs they would have incurred for their next batch of acquisitions, and look at what treatment we would recommend for those. I think depending on what decision the commission comes up with will determine how staff approaches that issue.
Why would you have a period of time where if it is, transition, I understand that we're discussing transition versus transaction here. Well, why wouldn't from the time, is it if they don't close on the system that you end up having an issue? I mean, I don't understand if it does go to closure and they had to start doing maps and engineering and a lot of the expenses, before they got that, why wouldn't those necessarily why wouldn't they count? Like, why do you have that time period?
Depending on the nature of the costs, I think they could count. But I think in this case, all these costs were deemed acquisition costs. And so when you're looking at whether or not you would include those, you've got transition and transaction. Let's discuss that. Transition costs are costs to really combine the operations. You've got 3 accountants in total in the old company and 4 in the other. And now you only need 5. And so all the costs to integrate the systems. And so there really aren't any transition costs for these systems that create the synergies that would cover transition and transaction costs. To answer your question.
Yeah, no, that is. Thank you, Judge.
And I want to make sure that the record reflects the attendance of Commissioner Glenn Kolkmeyer, who arrived some time ago and by my negligence was not mentioned. Are there any other commissioner questions? The bench has no questions. Let's move to cross-examination. Mr. Kleiser.
I didn't have any questions, and then you said something that I was just curious about. So you're saying that staff didn't come up with the 50 days?
No, I'm not, again, entirely sure how anybody came up with the 50 days. I was curious about Mr. Woodsmall's opening on that, but I haven't inquired to the company as to what the 50-day cutoff really means.
So what did you use to determine a cutoff?
I don't think there was really any cutoff. The company had identified these specific costs at issue as acquisition costs. And so if it was labeled as an acquisition cost, that was part of the removal. And I think the 50 days may be incidental to the information on the data request. But again, I think you'd have to ask the company or Mr. Teese about that.
All right. You said that you watched Mr. Woodsmall's opening, and I was there for it, and I could have sworn he said that you were slapping a label on things. So I want to make sure this is clear. You're telling me the company self-identified these as acquisition costs,
Yes.
and you didn't say these are the acquisition costs?
Not independently. I mean, the company said, there's a accounting chart field in the data request 88 that has a general cost category. I think it includes on for the improvements, repaired main or refurbished pump, what have you. And one of those accounting chart fields was acquisition costs. And so that's how the company identified those in the response to data request 88. Now, they had a separate response to data request 66 that had more detailed information.
And so staff is not saying cut it off after 50 days.
No, again, if you find out how they came up with 50 days, tell me, please. But I'm not quite sure what that's referring to. The company has identified independently these are acquisition costs, and so that's what we had to go. That's what I used.
I don't think I have. I don't have any further questions. Thank you.
Mr. Cooper?
One question, Mr. Majors. You talked a little bit about black box settlements with the chairman, and I just want to kind of make one point of clarification. Would you agree with me that staff-assisted rate case resolution documents, the disposition agreements, are a little different usually than a general rate case settlement or stipulation and agreement, in that many times those disposition agreements in the small company cases include the staff's EMS run?
Oh, for sure. And I think of the ones I reviewed, I think only one didn't have the EMS run, so I had to go hunt for that. But typically we include some kind of EMS run, whether it's partial or a full disposition agreement.
Yeah, that's included as an attachment to.
Sure, yes.
Yeah, thank you very much. That's all I have, Your Honor.
Thank you, Mr. Majors. You are excused from the, oh, I'm sorry, redirect. Mr. Thompson?
Thank you,
Redirect.
Judge. I'll try to make this as brief as humanly possible. Well, let me work backwards. First of all, can you explain to the commissioners what an EMS run is?
Yes, it's exhibit modeling system. It's the computer program through Microsoft Excel that we use for virtually all revenue requirement calculations.
So the staff accounting schedules, are those an example of an EMS run?
Yes.
And black box settlements, there was some discussion of those. Now, those are the result of negotiations, isn't that true?
Yes.
And do parties sometimes settle simply on the basis of the total revenue requirement amount?
Frequently.
So there is no specification of what that amount includes?
Yes.
And that makes it hard to answer commissioner questions about what particular items are worth.
In those cases, yes.
And you've already answered Mr. Kleiser repeatedly about the 50 days, and that's not a figure that staff uses or comes up with, correct?
It is not.
Now, when you have an amount that the company has identified as acquisition costs, how do you decide how to treat those costs?
Well, I think the examination is how is the commission treated. If they're not transition costs, then they really have to be transaction costs. How has the commission treated those historically? And to go back to, in plain English, the commission had the report and order in the Great Plains Energy Aquila merger case. I think going back to more black box merger agreements, that those really have, it's unprecedented to recover any kind of explicit transaction costs. And so that's what I relied upon to make my recommendation.
So you just employed the categories the commission had set up in that particular decision?
And other decisions, yes.
Okay, so in this case, Confluence is requesting rate-based treatment of those items.
Yes,
Now, rate-based treatment means they get a return on that amount. Is that correct?
yes.
And you spoke of an alternative treatment that you called amortization. Can you tell me how that's different from rate-based treatment?
Right, well, you can have an amortization without rate-based treatment. A good example of this would be there's a 5-year amortization of transition costs for the GPE, Westar, let's call it combination. I would call it a merger tentatively. I'm not sure what the legal structure of it was, but there was a 5-year amortization of those costs without rate-based treatment. And so you would include 1/5 per year of whatever amount you're amortizing without including those costs in rate base, as opposed to the treatment requested here, which would be including it in various plan accounts that would both earn a return of through depreciation expense from anywhere from 20 to 50-year lifespan, and a return on through the rate base rate of return calculation.
So it sounds to me like rate-based treatment is the most favorable treatment.
Yes, rate base and I would, yes, rate base and inclusion in plant. You could have rate base and an amortization. I think rate base and inclusion in plant, they would get the longest period of time where they would earn a return on the undepreciated balance of those amounts.
So when you talk about the amortization as an alternative treatment, do you mean amortization to expense?
Yes, and no rate base. I think that's been done in 2 or 3 of the example systems that were brought up in those cases in this case. So amortization to those expense, I think I've thrown out 5 years. Could be longer, could be shorter. Typically, the shortest amortization period when we talk about rate cases is around 3 years would be the shortest. It's kind of it's not an exact science on how long you set an amortization period for.
In your opinion, would it be just and reasonable to include these costs in rates as expenses?
Some of these costs, I think it's kind of a fair, happy medium. I mean, the commission has heard the testimony today about how these costs were incurred for the betterment of the entire system and for customers. And so I think at least some of those costs, depending on the category, I think would be a fair outcome to have some kind of amortization, no rate-based treatment, but the company would recover some of those costs over a period of time.
And when you say some, are you talking about a percentage, say 50% of them, 60%?
I think you could do a percentage. I think definitely the costs, the regulatory cost, the legal costs for coming in and applying for a CCN, those are really analogous to rate case expenses. I would not, they're certainly not normal as in rate cases in every 3 years. They're sporadic, so whenever they come in for a CCN to purchase a system. So I really don't think, those are just normal costs. No deferral treatment should be allowed for those. I think the engineering costs, the GIS have a lot of merit. I think some of the real estate, if it's for establishing right-of-ways, I think those definitely have merit. I think the schedules that I've been asked to provide to the commission would have some delineation as to which costs would be allowed and are more appropriate to put in an amortization.
Thank you very much. No further questions.
Thank you. Now, Mr. Majors, you are excused. Appreciate your testimony. Let's go ahead, and as you see, everyone has meetings to get to. For those scheduled meetings, let's call it at 1:30. 1:30 for everyone leaving the room, 1:30.
Before you go off the record, I'd like to address a matter of business. The commission ordered for Confluence to apply or provide us documents in our last motion to compel. We still have not received those. If I could get the commission to direct the company to provide the documents, which I believe were the memoranda, at some point today.
Judge, may I respond?
Yes, please.
We began collecting the documents that the commission ordered us to provide shortly after the agenda session last Thursday. I have not had an opportunity to communicate with folks in St. Louis to see where they stand with that. I would like to report to you after lunch, and we will produce those documents just as quickly as possible.
And I understand that's almost certainly what you're going to rule on, but I just want to remind the commission that the issue of this is addressing goes up tomorrow. So keep that in mind. Thank you.
Understood, and I would also state for the record that counsel for Confluence approached the presiding officer to state at the beginning of this hearing that they were working on that and would get it to them as soon as possible. Any other business before we go off the record for lunch? Again, 1:30. 1:30. No questions. We are adjourned and off the record. Thank you all. Just a quick announcement for those listening on the WebEx or in the live stream. First, please send Mr. Kleiser down to the courtroom. Second, we'll give Mr. Kleiser a few more minutes, and then we're going to go ahead and begin. The hour of recess having expired, this is a continuation of the general rate case of Confluence Rivers, file number WR-2023-0006. We are beginning the issue of timesheets, and we are going to start with mini opening statements. Confluence Rivers?
Thank you, Your Honor. If it please the commission, since this is the first opportunity I've had to appear in this case, I want to introduce myself. I'm Russ Mitten, and I have the pleasure to serve as general counsel of both CSWR and Confluence Rivers. That said, my opening statement regarding this issue is going to begin a bit unconventionally, because on behalf of both Confluence Rivers and CSWR, I need to offer a public apology to both the commission and the parties in this case. In two small staff-assisted rate cases decided in 2020 and 2021 involving two pre-merger Missouri affiliates, Elm Hills Utility Operating Company and Confluence Rivers Utility Operating Company, CSWR was ordered to implement a timekeeping system to track work conducted on behalf of those two affiliates. CSWR complied with that order by implementing a timekeeping system that tracks and records time not just for those affiliates, but for all its affiliates nationwide. However, at some point after the timekeeping system was implemented, 7 of CSWR's senior executives stopped recording time into the system. The rationale for that decision is explained in Mr. Cox's pre-filed testimony in this case, and he will be happy to further explain when he takes the stand to testify on this issue. He also will acknowledge that the unilateral decision of these executives to stop recording time was a mistake for which he will personally offer his apology. But despite that fact, Insofar as this case is concerned, the effects of the company's executive's decision to stop recording time were of minimal consequence in this case at best. There are several reasons I believe this. Some of those I will describe later in my opening statement, but for now, I want to focus on two. First, the two orders only required CSWR personnel to record time for work done for the two pre-merger affiliates. The order did not apply to CSWR's other Missouri affiliates or for work done on behalf of affiliates outside Missouri. Second, those two pre-merger affiliates account for fewer than 1,700 of the almost 10,000 connections Confluence Rivers currently serves in Missouri. So despite what staff stated in its testimony, the lack of timesheet data from the 7 CSWR executives posed no real threat to staff's ability to prepare its case. It's understandable that when dealing with a business structure like the one presented in this case, where CSWR performs all executive, managerial, engineering, legal, and other similar functions for its utility affiliates, including Confluence Rivers, regulators want to ensure that the portion of CSWR's costs that are directly charged or allocated to Confluence Rivers are both reasonable and appropriate. To aid regulators in that effort, CSWR created a cost allocation manual, or CAM as it's sometimes referred to, that prescribes how time spent by CSWR personnel is to be apportioned to its state utility affiliates. And based on our experience in rate cases in Kentucky, Mississippi, Louisiana, and Texas, regulators appear satisfied that either the three-factor formula set out in the CAM or some alternative allocation formula are alone sufficient to properly apportion CSWR's costs for rate-making purposes. I believe those utility commissions reached that conclusion for the same reason. They recognize that because of the dynamic nature of CSWR and its regulated affiliates, it would be impossible in the short run to try to determine a normalized level of service by CSWR for any of its state affiliates. My own experience at CSWR illustrates the wisdom of that conclusion. When I joined the company in 2019, CSWR had fewer than 20 employees and served less than 4,000 customers in 2 states. When I celebrated my 4th anniversary the month before last, CSWR had more than 80 employees and served almost 150,000 customers in 12 states. And the growth I've witnessed in the past will continue in the future because I'm personally involved in acquisition cases in all but one of the states where our affiliate group currently serves. And in addition, our group has filed its first acquisition application in the state of California. Over the course of my tenure, not only has our affiliate group grown at an unbelievable pace, which has resulted in ever-shrinking allocation factor applicable to Confluence Rivers, but I have both observed and experienced significant changes in the nature and scope of day-to-day responsibilities of CSWR's executive team. Certainly, year to year, if not month to month, those executives are required to devote more and more of their time to the enterprise as a whole and not to each of its individual components. While, as I noted, other state utility commissions have recognized the evolving circumstances I just mentioned and have dealt with the operational realities they represent, using a formula to allocate CSWR's costs. However, we recognize that, at least as so far as the commission staff is concerned, an allocation formula alone isn't enough for Missouri. But prospectively, we believe changes in the timekeeping system ordered in the prior two cases I discussed earlier are both justified and warranted. Over the more than 2 years the current timekeeping system has been in place, CSWR has been able to identify its strengths and weaknesses. Based on that experience, detailed daily time reports appear to have some value in documenting time spent by many lower-level employees whose day-to-day activities are easily identified to one or more of CSWR's state affiliates. This allows their time to be directly charged to the states receiving the benefits of their efforts. However, even for those folks, timekeeping is far from perfect because a portion of their time is devoted to activities that benefit the entire affiliate group, which must ultimately be allocated. But daily timekeeping is not so easily rationalized for CSWR's senior management team because the scope and focus of their job responsibilities more often than not are enterprise-wide rather than on an individual state affiliate basis. That's obviously not true for all their activities because, as the Commission has seen, several of our senior executives have been in attendance at this rate case hearing since it began and have focused their attentions almost exclusively on Confluence Rivers over that period of time. But these sorts of situations are very much the exception. And that fact makes it hard to justify the time, effort, and expense involved in requiring those senior executives to fill out daily timesheets, because even if they were required to do so, the largest portion of their time would be charged to the all companies category in our current timekeeping system, which means it too would need to be allocated. As an alternative to keeping daily timesheets, Confluence Rivers is proposing exception timekeeping for all CSWR employees at the director level and above. As proposed in this case, these senior leaders would create a time record only for activities directly related to a particular property or project, like participation in this rate case. All non-reported hours for these employees would be presumed to apply to all of the affiliates and would then be allocated using some sort of allocation formula. The company's proposal strikes a rational and appropriate balance between the commission's and staff's need for information and the desire for those executives to be freed from the obligation to fill out daily timesheet. At the very least, it's a proposal that ought to be tried. For all the reasons I just stated, Confluence River urges the Commission to adopt the company's exception timekeeping proposal. Our witnesses on this issue are Josiah Cox, CSWR's president, and Brent Teese, the company's vice president and controller, each of whom will be available to answer your questions regarding this issue in just a moment. That concludes my opening statement, and I'm available to answer questions.
Thank you. Are there any commissioner questions? Commissioner Holzman?
Thank you. So I think, how do you then, so what is the company's proposal then to ensure that Missouri ratepayers are only compensating for time spent on Missouri investments without being burdensome to the executives to have to fill out a daily timesheet?
With regard to the lower level employees, they will continue to fill out timesheets, and to the extent they can, they will identify Confluence Rivers and direct charge their time to that affiliate. For the senior leadership team, whenever they devote time to Confluence Rivers, as they're doing with this rate case, that would be reported as an exception, and that time would be direct charged. But because probably the majority, and in many cases, a significant majority of their time is devoted on enterprise-wise projects, you would then use an allocation factor to apportion that time to all the affiliates, including Confluence Rivers. We think that's the best way to do it. In fact, we think that's the only way you can do it, because for this company, what does a normal year look like? What happened last year is going to differ from this year. What happened last month is going to differ from next month. So there really isn't a consistent. We've got a three-factor allocation methodology that's proposed in our CAM. I will tell you that in the rate cases that we have been through in Kentucky, Mississippi, and Louisiana, the commission either used that methodology or came up with an allocation factor on their own.
Okay, thank you.
Thank you, Mr. Mitten. That takes us to Ms. Bretz for staff.
Good afternoon. May it please the Commission. My name is Karen Bretz, and I'm here on behalf of Commission staff on the issue of timesheets. What staff recommends is that Confluence do nothing greater, nothing less than it already agreed to, which is to keep timesheets for all employees. Most employees are keeping timesheets, the lower level employees are, and staff is fine with how that's being done. However, as Mr. Mitten mentioned, there are 7 executive level employees, and these are listed in Ms. Sarver's direct testimony on page 17, who are not keeping timesheets. First, I'd like to go through a little history just briefly. The parties reached an agreement in a prior Confluence rate case. This was case number WR 2020-0053. The Commission approved it and ordered all parties to comply with it. And on pages 2 to 3 of this agreement, Mr. Cox agreed to begin tracking time for Confluence activities conducted on behalf of CSWR LLC. And during this time, as Mr. Cox was acquiring systems and sought Commission approval for these acquisitions, he signed agreements stating that all employees would keep timesheets for the amount of time spent on each system. These 5 acquisitions are listed in Ms. Sarver's rebuttal testimony on page 6. And Mr. Cox readily acknowledges in his rebuttal testimony in this case that Confluence did not follow through on that. But it's not a matter of Confluence admitting we didn't do what we said we were supposed to do. We promised to do better in the future. What Confluence suggests moving forward is to apply a general allocator to time spent on Missouri systems. But for special projects, such I guess as this rate case, to allocate time on an actual basis. And this is what Confluence calls exemption reporting. Confluence suggests that this apply to executive and director level employees. There are more than 7 executive level employees listed in this would be more than the 7 executive level employees listed in Ms. Sarver's direct testimony. To summarize Confluence request, fewer employees would be keeping timesheets than currently are. Staff finds this problematic. Staff also finds Confluence's methodology, this exemption reporting, is backwards. The standard practice is for items to be directly charged when possible, because this is the most accurate way of charging. And to indirectly charge only if the items cannot be directly charged. What Confluence suggests is for executive and director level employees to charge their time on Missouri systems using the general allocator, except for the special projects, which I guess is going to be at Confluence's discretion, which at time they would begin directly charging. Confluence's reason for this request is that because it's rapidly growing, a general allocator is more representative of the time spent on Missouri projects than the actual timesheets. But the reality is that as Confluence expands not only in Missouri, but across the United States to California, having the most accurate information is critical to ensure that Missouri ratepayers are being charged the correct amount. Employee timesheets, which produces a direct charge, is the most accurate way to track and charge time spent on Missouri projects. Furthermore, Confluence executives are already keeping calendars. Staff received copies of these calendars through a DR request. It would not be a significant additional burden for the executives to use these calendars as a means of filling out their timesheets. That's what we do upstairs. It's not a big deal. And lastly, I add that what these 7 executives are doing is inconsistent with CSWR's employee handbook. If you will indulge, I will just briefly read a section of that. This was, staff got a copy of this through a DR request. And this is under the heading Personnel Administration, Section B, Timesheets. All employees are required to accurately complete and confirm a timesheet in the HRIS system, Paycor. Failure to submit a properly executed timesheet may cause a delay in the processing of the payroll check. All hours worked, as well as non-worked hours, i.e. PTO, holiday, etc., should be accounted for on the timesheet for that payroll period. Under no circumstances should hours be saved or banked for a later date by not reporting them in the period they were worked. Ms. Sarver brought up in her testimony that these 7 executives are not following the employee handbook, and no Confluence witness testified to the contrary. Just as staff looks to you, the Commission, for direction and leadership, CSWR employees look to Mr. Cox and the other executives for leadership. This is not good leadership. If most CSWR employees are doing what they're supposed to be doing, filling out these timesheets, but some people, namely the people at the top, are not. It's only prudent business practice for CSWR to keep timesheets. Staff's recommendation is that all CSWR employees keep timesheets. When Confluence was before you for their acquisitions and to get their rate increases, they were happy to say they were going to do that, but they didn't follow through. Please hold Confluence to its word. Ms. Sarver is available for any questions you may have. Thank you.
Are there any questions? Commissioner Holzman?
Thank you. What do you see as the main difference between an hourly employee and a salaried employee?
Well, speaking as a salary employee, I know that if I work more than 8 hours a week, I mean 8 hours a day, that I don't get overtime or anything for that.
Isn't the purpose of a salaried employee to provide the flexibility and the overage in a day? Because sometimes a salaried employee, especially an executive level employee, could potentially be presented problems that they would have to require their time outside of a traditional workday, outside of an 8 to 5 workday.
It provides flexibility, surely.
Do you believe that executives could potentially wake up in the middle of the night and contemplate business decisions at 3 a.m. and not have to necessarily take it down 15-minute increments for how they're spending their time?
Sure, of course that's true. But just as we have to account for our time, us employees have to account for our time here, so that gets allocated to the different utilities. CSWR should keep their time too, so that it can be allocated to the different systems.
Would you consider CWR a private or public company?
It's privately owned.
It's privately owned. So do you think a privately owned company should be able to set their employees on rather they're salaried or hourly?
Sure.
Okay. Thank
Yes, and they have set the rules out in the handbook, which says that all employees should keep timesheets.
Thank you, Judge.
Thank you. Any further questions for Ms. Bretz? Hearing none, thank you. And Mr. Kleiser.
Please, the commission. A lot of what I was going to say before has already been covered, and I don't feel like it's needing to rehash this. Honestly, when I was sitting there, I kind of scrapped my original opening, because as I thought about it, I started to think, gosh, this is such a silly, silly argument that we're dealing with right now. I mean, let's think about it. There's no dollar disallowance involved here. No money is being asked of the company whatsoever. We're purely prospectively. And all staff is asking is for this company's employees to do what just about every company's employees ask them to do, which is keep timesheets. It's what's asked of us at OPC. It's what's asked of your staff. Every single one of them has to keep timesheets. Apparently, though, this is far too difficult a task, which frankly seems a little bit concerning. I want you to think for a moment. Just imagine that you are going to a lawyer's office to acquire services. Let's like you're going to have a will drafted, right? And you get your will, it's drafted, and the lawyer turns around and he says, hey, instead of charging you the number of hours I spent working for you, we spend about 20% of our time drafting wills, so I'm just going to spend you 20%, I'm going to charge you 20% of whatever it cost me for that month. Is that reasonable? Are you okay with that kind of pricing structure? Because I wouldn't be. I would want to be charged for the work that was actually spent on me. And that's exactly what Missouri customers are asking of you right now. Missouri customers want to be charged for the work that Confluence does for Missouri. Okay, how do we figure out what Confluence does for Missouri? Well, it's pretty simple. We ask, hey, how much time did you spend working on Missouri? That's it. That's literally all they have to do is just write down, we spent this much time working on Missouri. So if they come to Missouri for an acquisition, they write down Missouri. If they go to Texas for an acquisition, they write down Texas. What happens if they didn't do anything? What if it's just a group meeting that wasn't specific? They write down company-wide. It's literally that simple. All we're asking them to do is something that literally every single one of your staff has to do on a daily basis. Is the most basic thing you could ask of this company. So please order them to do so. That's it. Thank you.
Questions, Commissioner Hahn?
Thank you, Mr. Kleiser. Bear with me for a moment as I kind of walk through something before I ask you a question. In my previous employment experience, I worked on multiple issues, all in a day, sometimes all in a night or in a weekend. I was a salaried employee, so I didn't get overtime or comp time, but that was just part of my responsibilities. And as Commissioner Holzman noted, sometimes it plagues your brain, and so you think of things in the middle of the night, you know, at 3 a.m. or 2 a.m., or you don't sleep that night because you have things on your mind. So in the hypothetical or the OPC position on this of requiring executives to have timesheets, how would you account for those hours in that time? How would you propose that Mr. Cox or his executive team account for the time that they spent after hours working on issues that are relevant to their operations in Missouri?
I think it's we need to be very careful here. We're not asking to compensate them on every hour spent. The reason for the timesheets is to come up with percentages, right? And yes, there's going to be a percentage that it probably goes to all company, and that is going to be allocated out individually. So to answer your question, if they record it on a timesheet as Missouri, it would be allocated to Missouri. If they record it as something else, it'd be allocated somewhere else. And if it's recorded as company-wide, it'd be allocated out according to general allocators.
So if it's after hours and there's a situation that comes up that's Missouri for 15 minutes at 7 o'clock at night, how is that allocated?
Did they record it on their timesheet?
How would you even record it?
By writing it down on the timesheet.
So you would have a timesheet at your, I'm just trying to figure out how this in practice would work. Do you have a timesheet at your home?
No, you would go to the office the next day and say, I worked on something on Missouri, so I'm writing that down on my timesheet.
For the following day for the evening hours?
I can tell you, I have also worked quite a lot of time after hours, and I also record that to my timesheet because I come in the next day and I say, I spent 4 hours after 5 working on this. It's not that difficult to write something down on a timesheet.
And just want to follow up, one more question. Imagine that you're on the phone, because I imagine they have lots of phone conversations. In 1 hour of their executive meeting, as Mr. Woodsmall mentioned that they have an executive meeting, you know, maybe 5 minutes of 55 minutes was allocated to Missouri for those executives. So do you think that they should be required to break down the minutes in which they spent on specific Missouri issues during that executive meeting, or how would you allocate that time?
I wouldn't personally ask for it as granular on a minute-by-minute basis. I think an hour-by-hour basis. And if you're in an hour-long meeting that touches on multiple different subjects, then you're going to record that entire hour for that meeting as general company. You wouldn't have to break it down on a minute-by-minute basis. I don't think staff is asking for that either. I might be wrong. I guess I'll ask staff in cross.
I think I guess then would staff propose giving them clear guidelines on how to allocate time? Because I think I can think of several scenarios where it might not be clear how to allocate time.
Well, let me start off by saying that I'm not staff, so I can't speak on their behalf. But, and I encourage you probably to ask this directly of Ms. Sarver, I'm sure that staff, if necessary, could provide guidelines to the company, assuming that the company's own internal guidelines aren't sufficient. Again, we're talking probably on an hour-by-hour basis, and to a certain extent, like if you spend 15 minutes after hours, if you want to write that down as company-wide, not. If you don't, then it's probably just going to go to the company-wide because that's what your default's going to be. So it's not that difficult. Does that answer your question? I don't think I did. So let's,
It's okay.
can I get clear guidelines?
Perhaps, yeah, I think perhaps I'll ask staff.
Okay,
Thank you.
all right.
Commissioner Holzman?
Thank you. So Ameren operates in Illinois and Missouri. Are Ameren executives also required to keep timesheets and turn them in?
I want to say yes, but I would not be 100% sure. I'd want to double check that.
Okay.
To my knowledge, the answer is yes, but I would feel more comfortable if I could double check. But I'm almost certain the answer is yes.
Okay, same with Evergy and all of the utility companies, their executives have to turn in timesheets?
I know for a fact Spire, for example, because I've seen the timesheets, and I believe I've seen Evergy's.
Okay. Would you think, is there a difference between an investor-owned utility and a private entity? I mean, is there a material difference in those two in your mind?
Do you mean specifically with regard to the timesheet issue? Because there's clearly a material difference between being regulated and not regulated. I mean, that's the obvious difference, but I think you meant something more specific to timesheets. Is that what you're going for?
I'm looking at it from your perspective of saying, we as a government entity do this, so they should have to do it too, even though they're a private entity.
Let's think about the logic, though. Why does your staff keep timesheets?
Well, I assume, and it depends, I think that we have such a variety of staff, like some will be on salaried and some will be an hourly employee. If you're an hourly employee, clearly you're keeping track of your hours worked.
No, the reason that your staff keeps timesheets is because that's the mechanism that's used to assign the commission's it's not appraisal, it's cost, assessment, thank you, fee. It's literally the exact same thing that's happening in reverse. So every utility has to pay a certain amount based on what the commission does for each utilities. So it's literally the exact same thing we're asking of Confluence.
But so what's the enforcement mechanism if they turn in a timesheet and they miss an hour, or they were, estimating? What's the consequence, or how's that going to be tracked or enforced or oversighted?
That would be part of the general auditing process that your staff would perform if they received the timesheets. If there were questions, they would ask questions. If they felt like there was a problem, they would try to address it. If there wasn't a problem or they couldn't find it, then there wouldn't be anything.
So if you were spending half an hour at 3 a.m. on an idea, and you said you were there for an hour, how are you going to justify the difference between that half hour and that hour, whether it was enforced or not?
Staff is going to perform an audit of the timesheets that they receive to try and determine what percentage of time was spent for each utility.
How are they going to know? I mean, it's 3 a.m. This is why you're a salaried employee. This is why, as an executive, you don't have regular business operating hours. So how is someone going to know if it's enforceable or not? Rather, someone claimed that they were working at 3 a.m. or not.
they're going to rely on the company to be honest.
Okay, so in that same token, why wouldn't an allocation system that's being proposed be relied on to be honest? Without having the burdensome of tracking time that appears to be difficult to enforce.
Because it's better than the alternative, which is to say, allow the company to have all of its executives working on outside of Missouri things. For example, expanding operations in Louisiana, Texas, Mississippi, et cetera, but then not charging or having Missouri pay for that, which is what will happen under a general allocator. Because it doesn't matter how much time they spent in Missouri or otherwise with a general allocator. Missouri pays about 8%, no matter what. And unless you have something that says, hey, this is how much time we spend in
Is
Missouri.
it possible that then Missouri could get a better return on the time that that executive might spend in this state that they're not paying for? Is that possible?
If you want to believe that somehow
I'm just asking if it's possible.
if Confluence were to spend more time in Missouri than its other states, the 10 other states, somehow, yes, that could be possible.
Okay, thank you. Thank you, Judge.
Thank you. No other questions. Thank you, Mr. Kleiser. Confluence, please call your first witness.
Company calls Josiah Cox.
That was the order that I had. Was Mr. Teese first?
Mr. Teese first then. Excuse me.
And Mr. Teese, welcome back. Just a reminder, you are still under oath. Please go ahead and have a seat. Mr. Mitten, your witness.
Your Honor, I believe Mr. Teese's pre-filed testimony has already been received into evidence, and he's available for cross-examination.
Ms. Bretz?
Okay, thank you. Good afternoon, how are you?
Doing well, thank you.
Do you recall a unanimous agreement that I think settled most of the rate case in WR 2020-0053?
Can you give me an explanation of what that docket number was?
This was a prior rate case, WR 2020-0053. A great deal of the case was, if not all of it, was settled by a unanimous agreement.
Okay, I'm not sure whether that was the one that was kind of the legacy Confluence systems or would have been under the name of Elm Hills Utility Operating Company.
It says Confluence Rivers Utility Operating Company.
Yes, I'm familiar with that, thank you. Thank you.
You've seen this agreement before?
Yes, yes,
Okay. And in this document, Confluence agreed to do certain things, right?
yes.
On the bottom of page 2, I've highlighted some.
Yes, I see that.
I know it's a little long, but could you please read that?
Continuing on to the next page.
Yes.
Okay, yep. Within 90 days of the effective date of an order approving this disposition agreement, the company shall begin tracking all work conducted on its behalf by CSWR LLC in the form of a time record. This time record will include a description of the job performed, length of time to complete, name, title of the employee who conducted the work, and tracked by each system. The time record information should be maintained in sufficient detail to capture the amount of time each employee spends on operation and maintenance activities as opposed to construction activities. The company also agrees that detailed timesheets will be maintained for any future employees Confluence Rivers Utility Operating Company Incorporated may retain. The company agrees to provide proof of implementing the recommendations to the manager of the Commission's auditing department.
Did Confluence do any of these things?
It's a little confusing because Confluence has never had its own employees, but CSWR has a time tracking system, yes.
So did CSWR do any of these things?
We began tracking work conducted. Yes, I'm not sure about I don't know what the form of the proof required to the manager of the commission's auditing department was, so I can't speak to that.
Okay. But CSWR began tracking time, but not for all employees, correct?
Well, clearly in this, there are a group of employees that were not tracking time, most recently, yes.
And why wasn't the time tracked for them?
So I think Mr. Cox will speak to the why. I think there's an executive decision about that, you know, he is more familiar with than me.
Did you track your time?
I did up through approximately the end of the company's test year, not the staff's, or not the test year that ended January 31st, but the test year we proposed that ended June 30th.
June 30th of 22. So why did you discontinue tracking time?
Honestly, I kept up and, you know, based on kind of the rate case schedule, and then got behind and failed to catch up.
You just got too busy on things?
Yeah, I mean, that would be the explanation, yes.
Would you agree that the items in this agreement are basically promises that Confluence agreed to keep?
You could describe them as such, yes.
When did you begin working for CSWR?
I began working for the company in 2017.
Okay. So you're familiar with the agreement, you're familiar with the Indian Hills case?
I am more of the, I was very new, so it certainly wasn't part of any negotiation or any settlement of that case, but I am familiar with it at a certain level.
Okay. I'm going to show you a copy of the partial disposition agreement in that case.
Okay.
So on the second page of that, I again highlighted a paragraph. Could you please read that?
I can. Within 90 days of the effective date of an order setting new rates for Indian Hills, the company shall develop improved timesheets for employee hours spent working on each system. This timesheet shall provide a description of the job performed, number of hours spent, and break out the hours by system.
So did CSWR employees follow this?
At the time, we were using Microsoft Excel for timesheets. So, yeah, again, I was new.
Your Honor, could I get some clarification? The document that Ms. Bretz just handed the witness, the word company is defined as Indian Hills Utility Operating Company. I don't see anything in this agreement that obligates CSWR to do anything.
The document is signed by Josiah Cox. I can just wait and ask Josiah Cox the same question since it's his signature on the document.
That sounds like problem solved.
Are you familiar with the rate case in WR 2020-0053?
Would that be for Elm Hills?
No, Confluence Rivers Utility Operating Company?
Yes, I believe I have some documents from that right here. Mhm.
Okay. I'm going to show you the unanimous agreement in that one.
Thank you.
I'll try to get that worked out later.
Ms. Bretz, did you just hand out
Yes.
0053?
Mr. Mitten just
Okay.
brought that up. I guess I need to talk to my secretary. So you have before you the unanimous agreement regarding disposition of small utility company revenue increase request, Confluence Rivers Utility Operating Company, right?
Yes.
Okay. So at the bottom of the second page, I highlighted some. Wait, did we just do that? Okay. I'm sorry, let's scratch that. Well, anyway, Mr. Tees, thanks for your patience with my disorganization. So we can agree that Confluence Hills did not follow what it said it would do in its last rate case?
Indian Hills, you're talking about the one that's highlighted in green?
No, in the last rate case, the rate case WR 2020-0053.
As Mr. Mr. Mitten described, most employees have kept, but there are certainly some employees who have not kept timesheets properly.
And you're aware that your employee handbook says that you're supposed to keep timesheets?
Yes,
And you agreed in this rate case that you would keep timesheets?
our company did, yes.
So there's been promises made in this hearing already, specifically having to do with customer relations and customer service. It's clear from these documents that Confluence did not keep the promises it said that it would keep. So how can we believe you that you're going to keep the promises regarding customer service?
I mean, I think promise singular, not promises. I mean, this is the only one that's before us as a broken promise so far. So, certainly we're willing to stand before the commission and own that. And so, never say never in terms of missing something or something going a little sideways in the future. But certainly we're talking about one promise here.
Okay, thank you. I don't have anything else.
Mr. Gleiser?
I have no questions. Thank you.
Any commissioner questions for Mr. Teese? The bench has no questions. I believe that takes us to recross. No, just redirect.
Redirect, Your Honor.
Yes.
Mr. Teese, just a couple of questions. Do you still have a copy of the document Ms. Bretz handed you, which is the unanimous agreement that was reached in case number WR 2020-0053?
Yes.
Now, she directed your attention to pages 2 and 3. Let me first direct your attention to page 1. Confluence Rivers Utility Operating, Inc. is defined as company in that agreement. Is that correct?
Correct.
So let's turn to page 2, if you will. And the language Ms. Bretz had you focus on, it says, within 90 days of the effective date of an order approving this disposition agreement, the company, Confluence Rivers Utility Operating Company, shall begin tracking all work conducted on its behalf by CSWR LLC. Is that what it says?
Yes.
Do you see anything in this agreement that obligates either CSWR or Confluence Rivers to track time for any other affiliated company?
Other than Confluence Rivers itself?
Yes.
No, I don't.
And by Confluence Rivers, this was the pre-merger Confluence Rivers Utility Operating Company, correct?
That's correct.
Let me direct, do you still have the document that Ms. Bretz gave you with regard to WR 2017-0259?
I do.
Again, could you turn to the first page of that agreement? How is the word company defined in the first line?
Indian Hills Utility Operating Company, in parentheses, company. So
All right,
it's
could
defined
you-
as Indian Hills.
Could you turn to the second page that she talked to you about?
Yes.
Within 90 days of the effective date of the order setting new rates for Indian Hills, the company, again, Indian Hills Utility Operating Company, shall develop improved time sheets for employee hours spent on each system. That's what it said. Is that correct?
Yes.
Do you see any obligation in that agreement for CSWR to do anything?
I do not.
And do you see anything in that agreement that obligates Indian Hills to keep time for any entity other than itself?
Not in this section, no.
I don't have any further questions. Thank you, Your Honor.
Thank you, and thank you, Mr. Teese. You are excused. Confluence, go ahead and call your next witness.
Josiah Cox.
And as Mr. Cox makes his way to the stand, I'll just remind him and everyone listening, he's already been sworn in, so he'll be seated and go ahead and start his examination then.
Your Honor, since, as you mentioned, his testimony has already been received, he's available for cross-examination.
Ms. Bretz?
Good afternoon, Mr. Cox.
Good afternoon.
I'm going to show you the agreement between Hillcrest Utility Operating Company and staff for the acquisition of Hillcrest. It bears Mr. Cooper's signature on your behalf. Could you please turn to the third page?
I'm there.
And in the paragraph that I highlighted, you promised that Hillcrest Utility Operating Company would keep timesheets for employees, all employees.
I see the company will develop and utilize timesheets. Yes.
Is there anyone exempt from that?
Not that I see.
So all employees is all employees, right?
I believe that's what it says, correct.
Was that done?
I do not know.
I'm going to show you the agreement for Raccoon Creek. This also bears your signature, the agreement for the acquisition. I turn your attention to the top of the third page. Again, it says that all employees would keep timesheets.
I see it.
Was that done?
I do not know.
How could you not know? You're the executive of the company, right?
Because I just don't remember. It's been quite a few cases ago. It's almost 10 years ago. I know we started to set up timesheets. We've been working on this all the way through the history of the company. 81 of my 88 employees have kept detailed timesheets, so we've been trying diligently, but have not, as we stated the first, the executives have not done a good job of doing this. It's been something that's become onerous and a Missouri-only activity.
You may have up there the agreement for Indian Hills. It's a 2017 case. Do you have that before you?
I do not.
Sure. I think we have it here. If you turn to the second page, again, the company agreed to keep timesheets. Do you recall if any were kept for that?
I don't recall, but I do see it.
Moving more up to current times, here's the agreement for Elm Hills. You turn to the If you turn to the third page, you see that again, there's an agreement to keep timesheets.
I do.
And you're aware in the WR 2020-0053 rate case, the Confluence Rivers Utility Operating Company agreed to keep timesheets?
Is that this case number? I apologize. You said you quoted a number that wasn't on top, so that's the only thing.
WR 2020-0053.
That's not what I have in front of me. This is Elm Hills.
Right, I gave my copy to Mr. Tees.
Oh.
But you recall the testimony on that Mr. Tees agreed that there was a part of that agreement where Confluence agreed to keep timesheets?
Yes.
Mr. Tees testified that he said that he kept timesheets until about June of 2022.
I heard that correct.
How long has it been since you've kept a timesheet?
I do not remember.
You don't know when you stopped filling out timesheets?
I do not.
So you heard me ask Mr. Tees this question, I'll ask it to you too. Already in the course of this rate case, Confluence has made promises specifically having to do with customer service. Confluence didn't keep promises it made in its prior rate case, and certainly you didn't keep promises that you made in the acquisitions. How can we believe it when you make promises now in this rate case?
I would quibble with that. I would say that we're 92% accurate on keeping timesheets. Only 7 employees have not done it. I would say that each one of these orders were a moment in time. I mean, these customers represent 1/150th the entire customer base we serve across the country. I would say that the timekeeping function alone, since Missouri is the only state that requires it, if you allocated the timesheet timekeeping function, would go over the percentage we're actually allocating towards the state of Missouri. So I think we've done a very good job of keeping our promises, especially when it comes to customer service and when it comes to service, delivering safe, reliable service. Unfortunately, we fell short on this, and that's why we're proposing another methodology so we don't fall short going forward.
I don't have anything else. Judge, I would ask to admit these exhibits, and I'm not sure where we are on numbering. Mr. Kleiser reminded me that the agreement in the 2020 rate case has already been admitted as an OPC exhibit. I'd like to enter the other, the agreements, or we could take notice of them.
I think there are 2 of them that have already been received into evidence, Judge. The Confluence Rivers case, WR 2020-0053, and the Elm Hills case number WR 2020-0275.
Your Honor, I can confirm the unanimous agreement regarding disposition of small utility company revenue increase request from Mo PSC file number WR 2022-0053 is OPC Exhibit 220, which has been offered and accepted. And the non-unanimous disposition agreement regarding of small utility company revenue increase request for Mo PSC file number WR 2020-0275 has been offered and admitted as OPC Exhibit 219.
Thank you. The 2 that I have remaining are for WR 2016-0064 Hillcrest and SR 2016-0202 for Raccoon Creek. Counsel, is that correct? Because these aren't my exhibits.
Sure.
Okay.
Okay, and what numbers are they going to be?
I'll look on your list.
They're not on the list. We'll file them late.
I'll look on your list for the next numbers.
Okay.
$134 and $135. Hillcrest will be $134. Raccoon Creek will be $135. I would like to correct staff's assertion that SR 2016-0202 represents an acquisition case. It does not. This is a rate case. The acquisition case was prior to that.
Thank you.
Where are we at? Commissioner, oh, no, Mr. Kleiser, questions?
It doesn't matter, I have no questions, but
Sold. Commissioner questions, Commissioner Holzman.
Thank you. I want to clear up a couple things. One, you said no other state requires timesheets. Is that no other state requires timesheets of anyone in your organization or just executives?
No timesheets for any employees.
So how do those states make sure that their ratepayers aren't being billed for time you're being spent in Missouri?
They use a corporate allocation method. It's essentially a division by the number of customers across the entire country, whereas Missouri is only paying for the number of customers they have compared to other states.
If, as a Missouri ratepayer, I would want to be assured that I'm not paying for time that you are spent in Texas. Earlier in this proceeding, you said you do more business in Texas because of the climate or other states because of the incentives. How is your company going to ensure the Missouri ratepayer that they are not being billed for time that you're spent in these other states?
Yeah, I answer that two ways. First of all, I would talk about the history of this. Originally, the first case that was mentioned earlier, Hillcrest, 100% of the time was dedicated to Missouri, right? Currently, less than 8% is dedicated to Missouri. And I would say just as a general rule of thumb from our perspective, Missouri takes more compliance work than any other state in the country. So if we weren't using a corporate allocation method, in fact, if we were recording time, it would be more to the state of Missouri than it would be to any other state in the country.
So the question I asked OPC of, is it possible that under a allocation where only 8% is being billed to Missouri, that Missouri ratepayers could be receiving more of your company's time than what that 8% represents?
I believe very much so that Missouri is receiving more of the time than the other states on a per capita basis.
Have you heard from any of your employees that are dissatisfied because executives are not keeping timesheets and they're required to?
No.
Thank you, Judge.
Any other commissioner questions? The bench has just one. I want to, this is going to be a little bit of a change of a topic. Page 2 of your direct testimony, you don't have to look it up. You said, starting in 2008, you took over operations of an existing rural sewer district. The next sentence is what I'm curious about. I still act as the administrator of the system. What system is this?
Oh, that should have been, that's a mistake. That's ceased 2 years ago, so I apologize. That's a remit. I've not seen that.
Not a problem. Thank you, and that'll take us to recross. Ms. Bretz? Nothing, thank you. Mr. Kleiser?
no
And
questions,
redirect.
thank you.
Just briefly, Your Honor, do you recall Commissioner Holtzman's question about how you would charge your time if you were spending time in Texas working on matters directly related to that state?
Yes.
Under the exception time reporting that we're proposing in this case, how would that time be recorded?
I would say I spent so much of a percentage of my time that's over and above normal allocation in Texas.
Thank you, that's all.
Thank you, Mr. Cox. You are excused. I'm going to take a break now before we begin with Ms. Sarver. We're just over an hour in, and instead of everyone needing to take a break in the middle of Ms. Sarver's testimony, let's stop now. We'll come back. I've got 2:36. Let's make it 2:45. Just under 10 minutes. on the record. The time for recess having expired, we are set to take up the testimony of Staff Witness Sarver. Before we do that, I have two quick announcements, two quick items to take care of. Yesterday, OPC witness John Riley testified, and I recall specifically that we discussed his pre-filed testimony because there was a remark made that it was the only testimony he filed was sur rebuttal. However, off the top of my head, I cannot recall, and I did not write it down, if we took in his pre-filed testimony. This is Exhibit 203. I do not expect any opposition, but I'll give council a few minutes to look through that while I make my other announcement. Advanced meter infrastructure investments. This is an issue for tomorrow. The parties had indicated that they were prepared to waive cross-examination. I would like to state that the commission has a question, and I'd like to state that question so then either the parties can come up with some way to get that answer into the record and continue with the waiver, or we'll proceed and question the witness. The commission's question is, this is on AMI, an issue for tomorrow. When were the AMI type meters installed at Hillcrest and Indian Hills respectively? Specifically, the commission is looking to find if those were installed before or after the acquisition.
Your Honor, our witness on that is Todd Thomas. He's here. He will be able to provide that answer to you if you want to take that up today.
No,
Okay,
tomorrow, but thank you.
okay.
Your Honor, I think that we should try and keep tomorrow, let's try and keep that issue off tomorrow, so I think that the parties can convene and see if we can't get you a way to answer that without having to call witnesses. That way we don't have to worry about taking up even more time.
That is my sincere hope. The magic of attorneys will make the issue go away. Let's move back to today, Mr. Riley's testimony, which is actually from yesterday. Exhibit 203. Go ahead.
I can't recall whether or not I offered it. I thought I did, but for the sake of the record, I offer the sur rebuttal testimony of John S. Riley at Exhibit 203.
You've heard the motion by council. Any objections to the exhibit being admitted? No objections. It is so admitted. Again, that is Exhibit 203. Thank you. Let's proceed now with Ms. Sarver. Thank you for your patience. And a quick reminder to our listeners, Ms. Sarver is still under oath, and she is seated, and it is staff's witness. Go ahead.
Good afternoon, Ms. Sarver. You previously testified in this case,
Yes.
and your testimony was... Oh, sorry. And your testimony was previously entered as exhibits...
Council, can you also get your mic? Thank you.
Thanks. Exhibits 107 and 131?
Yes.
Okay. I have nothing else, Your Honor. Tender Ms. Sarver for cross-examination.
Mr. Kleiser.
Good afternoon, Ms. Sarver. So were you here earlier for the opening arguments?
Yes.
So I got asked a couple of really good questions, and frankly, I'm probably not the best person to answer them, especially since I didn't actually make the recommendation. So I'd like to turn around and offer those questions to you so that the commission can hear from the person who actually made the recommendation. So let's start with the level of granularity. What level of granularity is staff proposing for timesheets?
Just the same that all the employees, how they keep their time, that's how you want the executives and directors to keep theirs. We're not here to micromanage them on their time.
What level of granularity is that, for the record? Is that an hourly, minute by minute, 15-minute increment? What are we talking
Right
about?
now, the current employees do 15-minute.
And you said that that's, okay. What happens if an executive has an idea at 2 in the morning and jots it down on a piece of paper? How would you expect that to be reported?
Just sometime before they submit the timesheet, they need to write it down, record it somewhere within the timesheet so they can just record that time.
So the next day?
Yes, the next day will be fine.
I'm trying to think through all the questions that were posed to me, and I'll probably just leave it off for the commissioners to ask those questions again themselves. You have previously seen timesheets submitted by CSWR's executive group, correct?
Yes,
And that includes, for example, Mr. Josiah Cox.
yes.
So he has previously, in the past, been able to provide you with timesheets.
In the past, yes.
And you have to keep a timesheet yourself, correct?
Correct.
Is your timesheet broken down by utility type?
By the case I'm working on, so yes, utility type,
So you report your timesheet by the case that you're working on?
yes.
And that breakdown is used to establish an assessment that the PSC levies against utilities, is that correct?
That is correct.
And that's because the PSC assessment fees are contingent upon the amount of hours worked by utility, right?
Correct.
So stated differently, electric utilities pay more in assessment fees because there are more PSC employee hours devoted to electric utilities than, say, manufactured housing.
Correct.
Would you agree with me that the cost causation principle means establishment of a causal link between a specific customer class, how that class uses the utility system, and the cost incurred by the water utility for the provision of service? Would you agree with me that's a fair definition of the cost causation principle? I can read it again.
Yeah, say it again.
All right. Would you agree with me that the cost causation principle means establishment of a causal link between a specific customer class, how the class uses the utility system, and the cost incurred by the utility to provide service?
There is a cost relation between all those. So yes,
And does maintaining a proper timesheet help ensure that cost causation ties between the employees and the system that cause costs to
Yes.
be incurred?
yes,
Would you agree, though, with me that a failure to keep timesheets would undermine this basic regulatory principle?
yes,
And it also, I would assume, creates a much of a challenge for auditors.
yes, it does.
So you had a significant challenge in working this case because of the lack of timesheets, is that correct?
It was just harder for us to allocate the cost to the appropriate system without timesheets.
Now, you're familiar with Confluence River's business model in general, right?
Yes,
And you would agree with me that they've set out and embarked on a rapid expansion program, is that right?
yes,
In fact, Mr. Cox's testimony, I believe, suggests that that rate of rapid expansion is one of the reasons they're not performing the timesheet function, is that right?
that is correct.
Based on that rapid expansion, isn't it highly likely that they are continuing to do far more work outside of the state than inside of the state related to the acquisitions across the 10 other states they currently serve?
We don't know that since we don't have timesheets, or we don't know the time spent on that.
You would agree with me that it's quite possible, though, that the company is actually spending far more time in other states than it is in Missouri, given its rate of rapid expansion in other states.
Yes, that's possible.
So right now, Missouri customers could effectively be paying for the work that Confluence is doing to acquire systems in other states.
Yes,
And the only reason that we would really be able to know that for certain is if we had some kind of mechanism to know exactly what Confluence is spending its time on.
yes,
And the best mechanism to have for doing that would be the time sheets, correct?
correct.
All right, I think that's it for me. Thank you very much.
Thank you, and Confluence Rivers.
Just one question, Ms. Sarber. Do you agree that over the last 4 years, the percentage of costs allocated to Missouri has gone down?
Based on the work papers and based on the corporate allocation that they've provided, I believe that statement is true.
Thank you.
Thank you. Are there any commissioner questions? Commissioner Hahn?
Thank you, Ms. Sarver. Earlier, I posed a question to Mr. Kleiser, and perhaps I should instead direct it to you. In a scenario where an executive is spending, going back and forth between subjects, perhaps in an hour-long conversation, maybe 5 minutes or 10 minutes of that time was devoted to Missouri. How would you, in your mind, have them allocate that time, or would you give them specific instructions on how to properly record their time?
No, we're not here to micromanage them. If they feel like they spent it on all utilities, all the states, then they can just write that down. Their timesheet right now allows for all utilities, so they could just mark it down as that. If it's an hour-long meeting and they talk about everybody.
Thank you. Just to follow up, are you familiar with the commission structure here at the Missouri Public Service Commission, the organizational structure?
Yes,
And so, would you agree that then all staff keep timesheets?
all staff, yeah.
What about commissioners?
I'm not sure about commissioners.
Would you agree that commissioners don't keep timesheets here?
I have no idea.
Okay. Thank you.
Thank you. The bench has no questions. We'll go to recross. Mr. Kleiser?
No questions.
Confluence?
No questions.
And redirect.
Just a few brief questions, thank you. Do you think it would be an undue burden on the for all Confluence employees to keep timesheets?
It's not a burden to the employees.
You told Mr. Kleiser that you keep your own timesheet.
I do, yes.
Can you estimate per week how long it takes you to fill out the timesheet?
Not very long. I mean, probably 2 minutes or less.
Would you anticipate that it would take more than a couple of minutes for Confluence execs to fill out timesheets on a weekly basis?
I want to think, around that.
Okay. You said after Commissioner Hahn asked you a question about how the commissioners, whether commissioners fill out timesheets. Are you aware that the commissioner's time is based on the allocation from the judges?
It could be.
Okay, thank you.
Thank you. Ms. Sarver, you're excused. That is going to take us to the end of issues for today, Monday, the 14th. Before I dismiss everybody, let's take a few minutes to level set. Yes, Mr. Kleiser.
From your topic earlier, my understanding is that the only issue that the commission has with regard to the AMI meter issue is to determine when AMI meters were installed in the Hillcrest and Indian Hills system. Is that accurate?
I wouldn't have said that was the commission's issue. That's
Not the issue, the question. I
inquiry. Yes,
apologize.
yes. I do not anticipate any other commissioner questions. And I understand that the parties have waived their own cross-examination, which means if the commissioners and the bench also do not have any, then the issue is submitted on the pre-filed testimony in the briefs. What I'm trying to do is get the information that was requested of me from you onto the record, which could be by a joint stipulation.
I was going to say a joint stipulation of facts. Would it be possible for the commission to write out its question so we make sure we get it answered exactly? And if not, I'll just take what you've said and then try my best to answer it.
Yes, I'll put it into writing this afternoon.
And email it to parties. Or
You want an email or an order or notice, something in EFIS?
An email's fine with the company, Your Honor.
Email's done.
okay.
Okay. Issues I have on schedule for tomorrow, Tuesday, August 15th. Cost of capital, advanced metering infrastructure, which we just discussed, and the water estimation, is that what we want to call it? we'll call it something else tomorrow. Those three, and just to let everyone listening know, with the estimate of the water usage, one of those witnesses is going to be available at 12:30. So we may be taking an adjusted lunch, almost certainly. We will be taking a different time period for lunch tomorrow. Mr. Woodsmall.
Yeah, just to be really clear, he's available from 12:30 on, so you don't have to schedule lunch around him. If lunch falls at 1, whatever, we can accommodate him.
Understood, thank you. Are there any other issues before we adjourn for the day? Excellent, we're off the record and adjourned. Thank you all. Let's go back on the record. The judge realizes that the parties did not suggest a time for tomorrow's beginning. I'm okay with 9. 9 it is. 9 a.m. Last issue, excellent. We are adjourned and off the record. 9 a.m. tomorrow.